One pending matter, my lord, second appeal of the year 2014. Delay condoned, my lord, on 17/5/23, but it has not been listed for admission, my lord. 2014 matter.
Next week. You are respondent?
No, I will put appeal.
Monday, Tuesday. I think
In item number 12, my lord, in I file for substitution may kindly be called for, my lord. I for substitution, my lord. File long back, my lord. In item number 12, my lord. That may call for, my lord.
who died?
Pardon, my lord.
Who died?
Two respondents died, my lord. One respondent, because one respondent's legal is on record, my lord.
Lordship, may I submit? Lordship, on behalf of AK Purkasha, I would like to submit that item 28 and 29 may be accommodated for the day.
20?
28 and 29
You want?
on the 17th after vacations.
Have informed the other side?
Uh,
What is the matter about?
Lordship is a ejectment suit.
Ricky, how many years you have been there?
But actually, yesterday while going for purchasing grocery, he made it an accident.
Oh. '28 and 29, when? After vacation?
Date may be, lordship.
28 and 29, at the request of the Learned Counsel for the respondents, half of the petitioner in CRP number 41/2022. Matter stands adjourned to be listed again on when? When do you want to get out?
On 17th, Lordship.
Your tenant?
Tenant.
Okay, when do you want to? 17th?
17th.
It's a holiday, that is why.
No, after the vacation. That's all.
Have it on 18th.
That's all.
Yes, what is this matter about?
But it's a remand, my lord. I am the defendant in the my lord suit and remanding and directing the my lord trial court to conduct a scientific investigation, my lord.
Funding where?
Page 23 is the my lord influence judgment and order. Page 26 is the my lord relevant portion, my lord.
Lordships, I want to submit one thing, Your Lordships. Although my name is Son Anand Jha, but I am not that Anand Jha, Your Lordships.
Where about that?
He is Nayan Jha.
Yes. Why is it remanded?
Page 26, my lord.
So I may be your
Last my lord paragraph, my lord.
Yes. Why the first appellate court could not have taken that if it was so it was found so necessary?
My lord, because earlier, my lord, in the trial court, my lord, the plaintiff has filed 2 applications, and that has been, my lord, rejected, my lord. Subsequently, my lord, after my lord judgment and decree of the trial court, my lord plaintiff preferred an appeal, and in the appeal, that remand order has been passed, my lord. And my submissions is that, my lord, I have filed 125 proceedings in the year 2000. And after my lord, order of the my lord maintenance in my favor, my lord, and in favor of my side, my lord, the plaintiff preferred my lord two revisions. In one, my lord, before the sessions court and one before the honorable court, my lord. And in both these revision petitions, my lord, the revision petition was dismissed, my lord. In my lord, thereafter, my lord, they have my lord filed this suit in the year 2007, my lord. If my lord, if any my lord regarding the my lord disputes regarding the marriage between the my lord plaintiff and defendant, my lord, they ought to have my lord filed immediately because I have filed 125.
Immediately, not immediately, can't the first appellate court take into account that and give direction for scientific evidence?
But there is no any issue, my lord, regarding the my lord that paternity issue.
Maybe. Couldn't the first appellate court do it by themselves?
My lord, but that my lord, the
Are you against that? Are you appearing on behalf of the appellant or the respondent?
I am appellant, my lord.
So the question which I am posing is in your favor. Are you understanding that or not?
Yes, my lord, that appellate court cannot, my lord.
Why? Why the appellate court can't exercise the powers under order 26
There is
rule
no
10?
any applications, my lord. My
Huh?
lord, without any applications, my lord.
So unless there is an application filed under order 41 rule 27, read with order for the order 26 rule 10A, the appellate court could not have done it. And against the order under order 26 rule 10A, there was an application which was filed, which was dismissed,
Two times.
and then they preferred a revision.
No. Revision against the my lord 125 proceeding.
Lahok. This is an appeal under section under order 43 rule 1T
You.
of the Code of Civil Procedure, challenging the order dated 31/3/2009, passed entitled appeal number 1/2009, whereby the learned first appellate court, that is the court of the civil judge,
Senior.
senior division Nalbari, had remanded the suit back to the learned trial court for which that word?
Is 26.
Under the for with a direction that the learned trial court directs for scientific investigation of the DNA as prayed for under order 26 rule 10A of the CPC at the cost of the plaintiff without delay. Full stop. This court have duly taken note of that the appellant herein, that the respondent herein, who was the appellant, did not file any application under order 41 rule 27 of the code for adducing of additional evidence. In addition to that, court finds no reason why the appellate court, which is the last court of facts, could not have directed the examination, could not have directed the scientific evidence be taken subject to fulfillment of the conditions in terms with order 26 rule 9 read with order 26 rule 10A. Under such circumstances, it is the opinion of this court that the impugned order dated 31/3/2009 is in contrary to the provisions of order 41 rule 24 of the code, and accordingly the instant order, the impugned order dated 31/3/2009 is set aside and quashed. This court directs the learned first appellate court, that is the court of the civil judge senior division Nalbari, to decide the said appeal on its merits. Full stop. It is however made clear that if any application is filed under Order 41, Rule 27, read with Order 26, Rule 10A of the Code by the appellant, the learned trial court, first appellate court shall duly consider within the scope and ambit in terms with the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin, reported in 2012, 8 SSC, page 148. Taking into account that the parties are duly represented, they are directed to appear before the learned trial court, first appellate court, that is the court of so-and-so, on 22nd of July, 2024. The learned first appellate court shall duly proceed with the appeal in accordance with law.
Obliged.
LCR, the registry shall forthwith send the LCR to the court, the learned first appellate court, that is the court of so-and-so, so that on the next date so fixed by this court, the said records are available. In that regard, the registry shall also employ if deemed fit, employ the services of a special messenger.
Obliged.
Yes, what is this?
Worship, my delay application has been rejected by the appellate
Huh?
court. My delay application has been rejected by the appellate.
Delay,
Delay, condonation of delay.
condonation delay, how are you filing a SAO?
That nomenclature is wrong. Lord. I filed under section 100, but the nomenclature was wrong. Lord. Page 26 is the in order. Lord. There is 60 days delay when
One.
filing that. So page 27 starts for page 27. Lord.
What is the court fee which you ought to have paid? You have to pay the court fee. Undertake to pay the court fee. I will convert it.
That is to be paid. Lord. That is to be paid. Lord. I undertake.
Will be a charge on you. The council to undertake to pay. If you
Okay.
don't pay, then obviously it
Okay,
will be
that I
dismissed.
undertake.
Appeal shall be dismissed. Raise the other side.
Actually, what happened, the respondent number 1, he is always absconding, he has not faced the trial also, and respondent 2 is Canara Bank.
Huh?
Respondent 2 is Canara Bank,
Raise Canara Bank. Service meted out.
service meted out lordship by order dated 2/11/15 law.
Service is complete. Why the delay?
After delay, I was suffering from lordship, Manila and diabetics and lordship,
Who was suffering?
and the plenty flux.
Huh?
The appellant,
Appellant was suffering from malaria and diabetes.
Melina,
Huh?
Melina law,
Melina. What is that?
occult blood lordship, that occult blood goes lordship, bleeding.
Did you submit the medical documents?
Lordship, I've submitted the medical certificate. That medical certificate has been scrutinized by the learned appellate court. Lordship will find at page 28, second paragraph. Lordship. I've gone through the petition and the medical certificate submitted by the on behalf of the petitioner and heard the learned counsel for both sides. It is submitted on behalf of the petitioner that he was suffering from diabetes, melena, and jaundice and was complete bed rest, for which he could not file the appeal within time. The learned counsel prays to condone the delay considering the medical ground of the appellant. It is also submitted that liberal approach should be made in considering the petition of condonation of delay. Learned counsel for the opposite party verbally submitted that the petition is not maintainable and the petitioner has failed to explain the delay properly. It is submitted that the petitioner, though submitted the medical certificate from 2/3/13 to 25/5/13 to explain the delay of 60 days after the last date of the limitation, but failed to show any reason of failure of filing the appeal within the actual period of limitation of 30 days. So learned counsel prays to dismiss the petition. After perusal of the petition and the medical certificate, it appears that the medical officer Naukala SSC Jagirot issued the certificate on 25/5/13, stating that Sri Vishnudev, son of such and such of Naukala, attended the OPD on such and such for his ailment of vomiting, severe anemia, along with aspiratic gastric tenderness. He was diagnosed as suffering from melena, effective hepatitis.
Wait. When was the judgment pronounced?
Lordship, judgment was pronounced 30/01/13.
2013. Okay, when did you file the appeal?
Lordship, I filed the appeal on Lordship 29/5, Lordship,
2013.
13, Lordship.
And then, how much was the stamp? You should have filed it by 2nd of March.
Lordship, 8th of March for certificate copy, Lordship. For the certificate copy, Lordship.
8th of March.
That, Lordship, the learned trial court, appeal court also calculated the same. The
8th
delay.
of March.
No.
You got the certified copy.
Lordship, I ought to have filed, but I took the certificate copy immediately on 28/3. I took the certificate copy.
Okay.
Though it was notified, that part was counted by the learned appeal court that I delayed in supplying the.
How did you get the certified copy on 28/3 when you were suffering from jaundice, melena, or
Okay.
whatnot?
Lordship, my advocate
Could not
submitted
file an appeal, but you could get a certified copy.
Lordship, that there was a delay of 20 days. My counsel submitted the stamp, Lordship.
The instant appeal. And this is an appeal filed against the order dated 5/7/2014, passed in Mirza case number 13/2013. In arising out of title appeal number. What's the title appeal number?
No. The title appeal has not been registered because delay.
No. They do register.
Lordship, page 23, Lordship. The title appeal is blank, Lordship.
File this up. এটা পিয়ন এটা কিনে দিব সোলজার হয়ে গেছে এটা পিয়ন এটা ভালো তখন দেখবো হয়তো This is an appeal filed challenging the order dated 5/7/2014, passed in Mirza case number 13/2013 by the Court of the Learned District Judge, Morigaon, whereby the application for condonation of delay was rejected there, and consequently, the appeal filed thereagainst was not entertained, being barred by limitation. Taking into account that upon rejection of an application for condonation of delay, it amounts to rejection of condonation of delay in filing an appeal against a judgment and decree. It amounts to confirmation of the judgment and decree passed by the learned trial court. The instant appeal is taken as an appeal under section 100 of the code. The registry is directed to re-register the instant second appeal, appeal as a regular second appeal, subject to deposit of the requisite court fee. This court have duly heard the learned counsel appearing on behalf of the petitioner appellant. Deposit of the requisite court fee. The learned counsel appearing on behalf of the appellant undertakes to pay the said requisite court fee. This court have also heard the instant appeal, the appellant, and is of the opinion that the following substantial question of law arises: whether the learned first appellate court was justified in rejecting the application for condonation of delay on the basis of the medical evidence, medical documents which was placed on record, and also in terms with the well-settled principles of law. Issue notice, making it returnable by 12th of August 2024. The petitioner, the appellant, is directed to take steps upon the respondent numbers 1 and 2, by way of registered as well as usual. The registry within 7 days. The registry shall immediately, the registry shall duly re-register the instant appeal and list it for hearing on the date so fixed. Number 3. I would have allowed you, but without framing a substantial question of law, it would not be proper.
Only one thing, may I submit? Substantial questions of law were framed, Lordship.
Framed
Lordship,
in an essay? Very good. Then I'll dispose of it.
Lordship, 11/5/2010, Lordship.
Oh, where is this question of substantial question of law?
5/2015, Lordship.
Okay, chalo. ऊपर खेलने में is an appeal filed under so and so for delay of demand. An appeal filed under section या ऊपर खेल लिखी दिबो. So एक ही नहीं पिके खेल नहीं. This court have duly taken note of and accordingly converts the instant SAO into a regular second appeal. The requisite court fee shall be paid by the counsel, by the appellant before the registry of this court. The learned counsel appearing on behalf of the appellant duly undertakes to make payment of the same. Next. This court have duly taken note of that on 11/5/2015, two substantial questions of law was framed, which reads as under Peter Didi. The question therefore arises as to whether the two substantial questions of law which have been framed are involved in the instant appeal. This court have duly taken note of that the judgment and decree were assailed in the appeal before the first appellate court was passed on 30/1/2013. However, the appeal could not be filed till 29/5/2013 on account of the appellant being suffering from diabetes, melena, and jaundice, and he was asked to be on bed rest since 2/3/2013 to 25/5/2013. The said aspect of the matter was supported by medical evidence, medical certificate, which was duly enclosed. It is further seen that the learned first appellate court had rejected the said application on the ground that the certificate pertains to a period post the expiry of the period for filing the appeal. However, from a perusal of the materials on record, it reveals that the appellant had time to file the appeal by 8/3/2013. 10/3/2013. Under such circumstances, the appreciation of the said fact by the learned first appellate court and rejecting the medical documents on the ground that the period for filing the appeal expired prior to 2/3/2013 amounts to a perversity on the face of the record. Under such circumstances, the two substantial questions of law which have been formulated duly are involved in the instant appeal. Accordingly, this court condones the delay in filing the appeal. This court accordingly sets aside the order dated 5/7/2014, passed in Ms. case number 13/2013, and condones the delay on the basis of the materials on record. The learned first appellate court, that is the court of the district judge Morigaon, is directed to take up the appeal, hear the appeal on merits post its registration, and after issuing due notice to the respondents in the said appeal. This court further takes note of that the instant appeal has been pending. The appeal was filed in the year 2013 and more than a decade have passed. Under such circumstances, this court fixes the matter before the learned first appellate court, that is the court of the district judge Morigaon, on 22/7/2024, on which date the appellant herein shall duly appear in the said appeal, and thereupon the learned first appellate court shall proceed with the appeal by issue in accordance with law. the registry, can you return the records and yeah, you pay that money. Paid it.
And number 3 and 4.
The instant order shall become effective upon deposit of the court fee. Yes, what are these?
Please, your lordship. My lord, this RSA use of 2016 lordships.
Why are two RSAs, SAOs? Mr. Ali, you have filed one?
Your lordship, this not RSA actually, this is a SAO, your lordship.
How?
Second appeal against order, your lordship.
Okay. Why, against what order?
To remand, your lordship, the matter was remanded by the appellate court, your lordship, with some directions
Why?
and to take some evidence, your lordship. Because it is not clear actually who is the owner of the land, your lord. Page 26, para 18, your lordship.
So, why couldn't the first appellate court decide this? Why the first appellate court could not decide that? Yes, the trial court made the mistake. The first appellate court,
Evidence is not sufficient, your lord. Evidence is not sufficient.
he has not dealt with that in this order.
That has been in so many words actually. that
No,
has been-
and whatever may be, if he
Sir.
wants official witness, did you file an application under order 41 rule 27?
Correct, correct.
Did you?
That has been considered, your lordship, at page.
Reduce
Your lordship,
additional
para-
evidence
para
holding the
16.
original sale deed
Page 25.
from the register remand. And after hearing both the sides, the predecessor of the young. So, why couldn't the first appellate court decide that?
Lordship, it is para 16, page 25.
16, I have seen it. The
During-
common order
during
under
the-
order 41 read to adduce additional evidence by calling the original sale deed from the sub-register, along with the connected registered books. After hearing both the sides, my learned predecessor in office passed an order that the said petition will consider at the hearing of the appeal. Okay, then how did he decide that?
No, that is the,
Nothing.
that is the your order 41, rule 27 petition, your lordship, it is not independently hard. It is always hard along with the final hearing.
Understood, but where is the decision out here on that? That because of these documents are necessary? And
Sir,
why couldn't he,
Later on, it has been discussed, your lordship.
where,
So may I read the prayer, your lordship? It is stated that in the judicial interest of the respondent Shanika Sohan and another had filed title suit number 148, 2007 against him for declaration of their right title and interest, confirmation of possession and for cancellation of the register, sale deed number 350,000 that is Chencho. On the other hand, the appellant had also filed title suit number 896 Chencho for declaration of right title and interest over the suit land. Confirmation of possession claiming interior that state Sanika Sohan had sold the suit land to him by registered sale deed number Chencho and also delivered possession. The learned court below dismissed the suit of the appellant and decreed the suit of the petition interest of the respondent. The appellant further stated that he had adduced his evidence in both the suits and exhibited relevant documents, including the certified copy of the sale deed as the original sale deed, which was not released and delivered to him by the officials of the sub-registers Bokor. Later on, he came to know that the said Sanika Sohan had filed a representation before the Deputy Commissioner Kamrup on Chencho
not to hand over and release the aforesaid document to the appellant. Therefore, he could not succeed in obtaining the same and producing the same before the learned court below. It is alleged by him that due to lack of instruction from his engaged counsel, necessary steps could not be taken by him for calling for the original sale deed from the office of the sub-registrar Boko, in spite of the information given to the then engaged counsel regarding the aforesaid complaint lodged by said Sanika Sohan. Further, due to lack of instruction from the council, appellant even failed to produce the certified copy of the sale deed on the date of his cross-examination, and as such, the most vital and important piece of evidence was left out in the case from being proved as per law. This apart, the appellant did not take any steps for calling the relevant documents of sale permission from the office of the deputy commissioner to prove the fact of sale of the suit property by said Sanika Sohan in his favor, as he was not properly guided by the then engaged counsel. It is urged by the appellant that he has purchased the suit land by valid and legal sale deed number so by paying valuable consideration, but the trial court, without considering the said sale deed, decided the issue for which he has been deprived of from his legitimate claims. Further argued that deciding the issue number 4 by holding the appellant failed to prove his title over the suit land by adducing evidence, and as such, the title remains with the respondent, being legal heirs of Sanika Sohan and Abotraj Sohan is forward. On perusal of the entire record of the title suit and its evidence, it appears that the court below came to conclusion of the suit without perusing the sale deed in question or by examining the official relating to the office of the sub-registrar Boko, wherein the sale deed was executed. The court below ought to have examined and considered the sale deed in original in question for proper.
Why the first appellate court could not have considered it?
Your Lordship, my prayer is, Your Lordship, the first appellate court may be directed that additional evidence may be taken up by it.
By the first appellate court.
That was not done, Your Lordship, that direction.
The first appellate court at the time of writing the judgment, if it felt, yes, it is the requirement that we should have that thing. And as such, the first appellate court could have very well called for those original. Why is it for the purpose of remanding? Otherwise the first appellate court becomes useless.
Correct, under whatever rule to summon, that court has the power. So
Why
only,
should I direct?
only thing, Your Lordship.
This is not a ground. This is not a ground for transfer.
Remarkable.
And in fact, in a recent judgment of the Constitution bench in the case of Asia resurfacing, the Supreme Court categorically says that this remand should not be made. And because of this
Sir, it
remand,
should be
today the
still
matter, the appeal, which is of the year, has been there for how much? How long? 10 years.
Your Lordship, that direction may be given to the appellate court that you decide under order 41 rule station, whatever documents are necessary for it.
The
And
first appellate court has the power, isn't it? If he wants to take evidence, they can very well take evidence.
The council actually failed to instruct us, Your Lordship, that what it is given for proving this LD. That was the problem. Actually, it is reflected from the order 41.
And he doesn't mention anything. He says he puts the fault on the learned trial court. When you have not taken steps before the trial court, how can you put a fault on the learned trial? And this is not the basis on which he exercised the powers under Order 41, Rule 27. In the interest of justice or for delivering a judgment, he requires that. Very well, he should have. So, you can appeal the whole. And why? Because of both appeals, 2 appeals. Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the appellant, both the appeals. And Mr. S. Ali, the learned counsel, appearing on behalf of the respondent, both the appeals. Both the appeals are taken up together by this for disposal, taking into account that by a common order dated 17/11/2014, isn't it? 3/12/2014. Both the appeals taking into account that by a common order dated 3/12/2014, both the suits being title suit number 896/2006 and title suit number 147 the judgments and decree passed in title suit number, the common judgment and decree dated 27/5/2011 passed in title suit number 896/2006 and title suit number 147/2007 was set aside, and the learned first appellate court has remanded the said suit, both the suits, to the learned trial court for a fresh decision on the basis of fresh decision by decision to pass for a fresh decision discussing all issues by examining the original sale deed number 350/2000 dated 21/11/2000, and if necessary by examining the registers, concerned officials of the sub-register BOCO in regard to the sale deed. I've heard the learned counsels appearing on behalf of the parties. Before dealing with the legality and validity of the impugned order dated 3/12/2014 passed by the learned court of the civil judge Kamrup Amingam, entitled appeal number 46/2012 and title appeal number 44/2011, are both the same. The बेलेग order होगा, हाँ? The same order, but पता order did ले इतने एक ही होता है, हाँ? ये क्या लिखो? On behalf of the respondent. The instant appeal, on number 3 of 2016. The instant appeal, you can appeal under order 43 rule 1U. 1U. Demand is 1U. Of the Code of Civil Procedure 1908, for short the code, challenging the order dated 3/12/2014, passed in title appeal number 46/2012, whereby the learned first appellate court, that is the court of the civil judge Kamrup at Amingam, had set aside the common judgment and decree dated 27/5/2011, passed in title suit number 896/2006 and title suit number 147/2007 by the learned Munsif Kamrup, Guwahati, for short the learned trial court, and thereby remanding the suit back to the learned trial court to pass a fresh judgment in all issues by examining the original sale deed number 350/2000 and dated 21/11/2000, and if necessary by examining the registers, concerned officials of the sub-register, BOCO in regard to the said sale deed. from the materials on report, it reveals that that the predecessor in the interest of the appellants herein had filed a suit being title suit number 2000 against the respondent herein taking declaration of their right, title, and interest over the property described in the schedule to the plain for declaration that the sale deed bearing deed number 350 dated 21/11/2000, which was purported to have been executed by the plaintiff number 1, was illegal, void, inoperative in law, semicolon, for cancellation of the sale deed number 350 dated 21/11/2000 being void, illegal, inoperative, and for mandatory and perpetual injunction. The defendant, the respondent herein, who was the defendant, has filed a written statement denying the case of the plaintiffs. It is also relevant to take note of the respondent had also filed a suit being title suit number 36/2001 against the appellants herein, against initially the predecessor of the appellants. And subsequently, upon the death of the predecessor against the appellants herein, in the said suit, the respondent as plaintiff sought for a declarative decree, a declaration declaring his right, title, and interest over the property described in the schedule to the plaintiff for confirmation of possession and also a permanent injunction restraining the defendants from interfering with the peaceful possession of the plaintiff over the suit land. Subsequent thereto, on account of the pecuniary jurisdiction of the courts having changed in view of the amendment to the Assam, Agra, Bengal, Agra, Assam Civil Codes Act 1887. The title suit number 62/2001 was renumbered as
Yes, 896 of 2006.
Huh?
896 of 2006.
renumbered as title suit number TS number 896/2006.
2006.
Pustak. The title suit number 32 na?
Also,
36/2001 was also renumbered as title suit number 148/07. Taking into account that both the suits, the scheduled property was one and the same. Both the suits were consolidated. And by a common judgment and decree dated 27/5/2011, the learned trial court partly decreed title suit number 148/07. That is the suit filed by the appellant, respondent hearing.
Lordship, appeal.
148 is who?
We didn't make it. We did not ask. for-
148 is yours.
Is your lord.
Please.
896 is mine, your lord.
So 148 became which one?
Lordship,
Title suit 62 became what?
year 62 of 2001.
Became
Against that 148.
148/07 only. 62 of 2001 became 148/07. And title suit 36 of 2001 became 896/06. That by a judgment and decree dated 27/5/2011, partly decreed the suit of the appellants herein, thereby declaring that the plaintiff had right, title, and interest and possession over the suit land, and dismissed the suit filed by the respondent herein, that is title suit number 896/06. Being aggrieved, two appeals were preferred by the respondent herein, being title appeal number 46/2012 and title appeal number 47/2012 and title appeal number 47/2014. In both the appeals, by separate orders dated 3/12/2014, the suits were remanded back to the learned trial court for a fresh decision by examining the original sale deed number 350/2000 dated 21/11/2000. And if necessary, by examining the registers, concerned officials of the sub-register, BOCO, in regard to the said sale deed. Being agreed by the order dated 3/12/2014, passed in title appeal number 46/2012, the present appeal has been filed. Itut lekhibo, ikhoro karone lekhibo, being agreed by the year order passed in 47/2014, dated again, the present appeal has been filed. Now, this court have heard the learned counsels appearing on behalf of the parties and have given due consideration to the respective submissions. From a perusal of the impugned order dated 3/12/2014, it reveals that an application was filed under Order 41/27, read with Section 151 to adduce additional evidence by calling the original sale deed number 350/2000 dated 21/11/2000 from the sub-register BOCO, along with connected registered books, etc. It seems it appears from a perusal of the impugned order that there was no attempt being made by the respondent hearing before the trial court to call for the original of the deed of sale bearing sale deed number 350/2000 dated 21/11/2000, or for calling for the connected register of the books, etc. The learned First Appellate Court, however, did not consider as to whether the said documents were necessary for the purpose of deciding the appeal. Said evidence is necessary for the purpose of deciding the said appeal, which is the mandate of law in terms with Order 41/27 and the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin, reported in 2012, 8 SCC, page 148. The learned trial court, a First Appellate Court, simply shirked its responsibility and remanded the matter back to the learned trial court, holding inter alia that the learned trial court made the mistake in not perusing the sale deed in question or examining the officials relating to the office of the sub-register BOCO wherein the sale deed was executed. The said observations made by the learned First Appellate Court in its order dated in the impugned order dated 3/12/2014, in the opinion of the in the opinion of this court, was not at all called for. In addition to that, this court finds it also relevant to take note of a recent judgment of the Constitution Bench of the Supreme Court in the case of High Court Bar Association Allahabad versus the state of UP and others, reported in 2024 SCC Online SC 207, wherein the Supreme Court have deprecated the casual approach of the courts in remanding the matter back to the trial court. It was observed by the Supreme Court in by the Constitution Bench of the Supreme Court in the said judgment, more particularly at paragraph number 14. That in our legal system, inverted comma, which is facing a docket explosion, an order of remand should be made only as a last resort. The order of remand not only results in more delays, but also increase the cost of litigation. Full stop. Therefore, to avoid the possibility of passing an order of remand, the grant of stay of the proceedings is called for in many proceedings, inverted comma. Full stop. In the instant case, the instant impugn order is a prime example of the casual approach taken by the learned First Appellate Court in remanding the suit back to the learned trial court. More so, in view of the statutory prescription contained in Order 41, Rule 24 of the Code. Under such circumstances, this court sets aside the order dated 3/12/2014, passed in title appeal number 46/2012, and directs the learned First Appellate Court to decide the said appeal on its merits. This court also observes that if the learned First Appellate Court, which is the last court of facts, is of the opinion that the deed of sale dated bearing deed number 350/2000 dated 21/11/2000 is required, the same exercise can be very well done by the learned First Appellate Court, and there is no requirement for remanding the said suit back to the learned trial court. Accordingly, this court therefore sets aside the order dated 3/12/2014 and fixes the matter and directs the learned First Appellate Court to decide the said appeal on the basis of the observations herein above, directions and observations herein above, and taking into account that the parties are duly represented, this court fixes the matter on 24th of July before the learned trial First Appellate Court, that is the court of the civil judge Kamrup Amingaon. Full stop. By any registration area. Both appeal dismissed.
I. My lord. Appeal number 2 has expired. Appeal number 2. He has expired and we can file a petition.
When did he die?
Petition. And have been earlier given a number. That number doesn't, when we have entered, when this.
When did he die?
Died on 30th November 2016.
When?
Thereafter, we have filed it. We have filed it in this 2022. We have been given a number. That number appears to be when we have entered it is of a different. Number that was given to us.
Who died?
It's appellant number 2, my lord. That is Shurikan Baba.
Plaintiff.
He was one of the plaintiffs.
And?
Suit was decreed by the learned trial court. Thereafter, when it went on opposite party, they preferred an appeal against the counter, not against the suit. So for the record suit. Thereafter, the learned appellate court has remanded back, framing 5 additional issues.
And?
So thereafter, we have filed this because these that have been framed by the learned appellate court. Already it covers because earlier 11 issues were already framed and has been decided by the learned trial court. And in the appeal itself, it is clearly mentioned that they are aggrieved by the judgment and decree because the dismissal of the counterclaim.
Where is the bar of limitation in respect of the counterclaim?
Counterclaim, my lord. They have referred it in this thing. in
No,
the-
where's the issue earlier that it is barred by limitation?
My lord, this step that has been framed by the my lord, in 7 and 8. 7 and 8 of the, whether there is cause of action for the counterclaim and whether the counterclaim is maintainable in form.
Where is the plaint?
Plaintiff is along with this case number, IA number 7775. Copy of the plaintiff is and
Where is the plaint?
plaintiff at page number in case number in IA number 775 for 2016 at page number starts from page number 10 as an example.
Plaintiffs are the daughter of Ilzan Beva.
Yes, Diljan Beva, the son and two daughters. Diljan Beva.
And she died in year 2016.
Plaintiff's mother, that is Diljan Beva, she died in September 2001. There is no dispute.
No, we are concerned of Suruton Beva.
Diljan Beva, she died in 2016.
And you have not filed any application.
Filed it in 2002 when we have been engaged in this and we inquired about the parties and all. Thereafter only,
Then what happened?
then thereafter we have been provided with a case number. But that case number appears to me when this item is listed in hearing. We are expected that it will come up for order. But it has been listed for hearing. Thereafter we inquired and we found that this, whatever number has been given here, IA 1471 2022, that relates to a different thing.
What is wrong with the order?
Order, my lord. The order is that the learned were appellate court. That is the first appellate court was demanded that the issue, that this issue got to be additional issue. That is, my lord, in page number. That 38 may kindly be told. Here, additional issues have been filled.
So, what is wrong?
My lord, if these issues are failed, learned, your appellate court could have decided it because evidences were all recorded. evidences are there. On the basis of that evidence, the learned lower appellate court decided it. After framing the issues here, again, learned lower appellate court has remanded back, and it is that if the parties desire, they can adduce further.
Show me that issue number 12, additional issue number 12 is anywhere connected with the earlier issues frame.
Here. Whether the defendant entered into a legally enforceable contract with Region BB to purchase 3 kata 15 lessons of Schedule B land. If yes, whether the defendant number 1 has delivered the possession of the suit land as a part performance of the aforesaid contract. My lord. Here. If learned, if the lordship kindly peruse this, that the issue number.
It does not. Rightly. Miss this appeal. I will go there, do whatever you want. Appeal file under Order 43, Rule 1U of the Code of 1908, challenging the order dated 8th of September 2015, passed 30/2012, whereby the learned First Appellate Court, that is the Court of the Civil Judge Dhubri, being found that the learned trial court had not correctly framed the issue, many of the vital issues. And in absence of those issues, the question of evidence may have to be led, remanded the suit back to the learned trial court, thereby directing the parties to appear on 12/10/2015. This court have duly perused the judgment, the order dated 8/9/2015, and from a perusal of the said judgment and also the pleadings exchanged between the parties, is of the opinion that the impugned order by which the suit was remanded on the ground that the vital issues having not been framed does not call for any interference. Also, taking into account that the additional issues which have been framed do not in any manner touch upon the issues which were framed by the learned trial court. Considering the above, this court therefore dismisses the instant appeal. The parties who are duly represented are directed to appear before the learned trial court. That is the court of the, which one?
How it will be in Harsini matter, because a new court has been set up in Harsini. Munsif court.
It was before whom?
It was before Munsif.
The court of the learned Munsif number 1, Dhubri, on 24th of July 2024. The learned Munsif number 1, Dhubri, shall decide the said suit being title suit number 79/2005, terms with the directions so passed by the learned First Appellate Court dated 8/9/2015. Mr. Name? So and so, the learned counsel appearing on behalf of the appellant submits that taking into account that the subject matter of that the suit land now presently falls the suit land being at Hatsing Mari. Suit land is where?
Upland is at, my lord, it is at
Land is at Mankasar.
Pankaj.
Answer, sir, the court of the civil judge, Munsif at Hatsing Mari shall have the jurisdiction to decide the said suit. Gustav. The said aspect of the matter can be brought to the attention of whom? Hatsing Mari will belong to under whom? South.
It's a separate
Eh?
South Salmara district.
Yeah.
Earlier-
Gustav. The said aspect of the matter may be duly brought to the attention of the learned Munsif. Number one, Dhubri, who shall be at liberty to pass appropriate
My lord,
orders.
and I right for that, for substitution may kindly be.
Has also been brought to the notice of this court that the respondent appellant number 2 had expired. In the meantime, Gustav, the petitioner would be at liberty to file appropriate application. The appellant shall be at liberty to file appropriate application before the learned trial court.
Item 6.
তার পিছত he would liberty send the LCR back to so and so that it be messenger. Yeah. I fixed the matter on 24th, na?
24th July.
24th July. Yes, who is there? Item number 6. None appears on behalf of the appellant on cause. Under such circumstances, court dismisses the instant appeal. Frequently, stay as an answer. Frequently, the registry is directed to return the LCR back to the court of the learned Munsif, number 1, Tinsukia, for deciding the said suit in terms with the impugned order dated 30/6/2016. The registry shall forthwith take appropriate steps for return of the LCR. The learned trial court shall proceed with the adjudication of the said suit as directed by the learned first appellate court by issuing due notice to both the parties.
7.
Yes, what happened?
My lord, this matter may be taken up tomorrow, my lord.
Huh?
My
What?
Mr. A. Sattar, my lord, the council appearing for the appellant's.
What happened?
It's my prayer that the matter may be taken up tomorrow.
Okay, don't worry, we'll take it up tomorrow. I will sit here only for you tomorrow. Okay. Take at 5:45 for you. And the entire court expenses, you have to bear. Done. Them additional hours, including the electricity, everything. Don't come up with all these submissions. It's already there on the cause list, no adjournment in this matter. Argue.
This was filed for recovery of declaration of right having interest, recovery of possession and injunction. However, we were the defendants, we are in appellants.
Where's your plane?
My lord, the plain says on page 39.
Please? Yes, Mr. Dole. You are the defendant.
I am the plaintiff, my lord.
Where is the defendant? Where have you taken the point that the suit land is not identifiable in your written statement?
My lord, we have not, however, my lord, it was observed in the judgment.
Forget about that. Where have you taken that the land is not identifiable?
Yes,
In fact, paragraph 27, they have been admitted of the written statement, page 52.
Paragraph 27, what does it say?
They have admitted that the transfer was made.
Understood.
But the suit-
Where is the
No,
fact that there is not? So how did the first appellate court frame that additional issue?
my lord, because in the trial court, the suit was
Understood,
dismissed.
an issue will be framed on the basis of the evidence, on the basis of the pleadings. Isn't it the basic idea of order 14 rule 1? So under such, where is the question of framing an additional issue? Whether it is identifiable, not identifiable, for the learned first appellate court to decide yes or no. Whether he is right or wrong, and find out yes, because there is no denial to the fact that it is not, there is no contradiction to that effect that it is not identifiable. His suit categorically says that this suit land is as per the schedule, which is bounded by boundaries. Then how could the learned first appellate court remand it? To allow your appeal. Okay.
My lord, the trial court has dismissed on this plea only that suit land is not identified.
Whatever may be, who filed the appeal?
We
You
plaintiff,
say it is identifiable. The first appellate court should have decided that. The first appellate court does not come to any finding to the effect that it is not identifiable.
since because the trial court has come to the finding,
Trial court may come to whatever finding. That is their lookout. When it is identified by the plaintiff categorically, the defendant categorically do not deny to that effect, then where is the question of the court coming to that an issue is to be framed? The first appellate court has to decide on that aspect. Hello.
in fact, we have filed two applications before the first appellate court. Under
You can very well file an application for the Amin Commission. If it is not identifiable, order 29, 26 rule 9, have you done it out there before the trial court?
no, my lord, we have in fact filed one application under order 41 rule 27.
Along with 26(9).
Yes.
So the first appellate court can very well direct if it is not identifiable.
Yes.
That's pending.
That is not been disposed of.
Okay. Okay. Get your guts ready. You should have. This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure 1908, challenging the order dated 26/8/2016, whereby the learned first appellate court, that is the court of the civil judge Kamrup Amingao, had remanded the suit back to the learned trial court by framing an additional issue as to whether the suit is identifiable or not. This court have duly takes note of this court have duly perused the copy of the claim enclosed to the instant memo of appeal, wherein it is seen that the appellant, that the plaintiff have filed the suit claiming a right title and interest over the scheduled land, which is described in the schedule with proper boundaries. This court have also duly taken note of the written statements so filed by the defendants, wherein there is no issue, there is nothing mentioned that as regards the identification of the boundary of the scheduled land. Under such circumstances, taking into account the provisions of Order 14 Rule 1, 14 1,
Yes.
of the code, the question of framing an additional issue as to whether the suit was identifiable or not was not material, or was not necessary. It may be a fact that the learned trial court may have dismissed the suit on stating that that no decree can be granted as the suit land was not identified. However, it is the duty of the first appellate court to decide as to whether, without there being any dispute to that aspect, whether the learned first trial court was justified in doing so. It has also been brought to the attention of this court by Mr. Adhor, the learned counsel, appearing on behalf of the respondent, who is the plaintiff in the suit, that an application was duly filed under Order 41, Rule 27 of the code, read with Order 26, Rule 9, for the purpose of issuance of an Amin commission, and the said application.
Commission was not filed, order 47.
I filed an application under Order 41, Rule 27 for the purpose of adducing additional evidence so that an Amin commission, an Amin commission could have been appointed by the learned First Appellate Court, if so necessary, to identify the land. So it has been further submitted that the said application was duly pending. So under such circumstances, this court finds no justification in the order passed by the learned First Appellate Court of remanding the suit. Impugn order passed by the learned First Appellate Court on 26/8/2016, thereby remanding the suit back to the learned trial court. In the opinion of this court, the learned First Appellate Court, being the last court of facts, would be also within its jurisdiction to exercise the powers under Order 41, Rule 27, read with Order 26, Rule 9 of the code, if so necessary, for the purpose of delivering the judgment, subject to the judgment. So, under such circumstances, this court finds that the impugned order dated order dated 26/8/2016 is contrary to the provisions of Order 41, Rule 24 of the code, and accordingly since decided and quashed. The learned First Appellate Court, that is the court of the Civil Judge Kamrup Amingao, is directed to decide the said appeal, and in doing so shall also duly consider the application which is presently pending, being an application under Order 41, Rule 27, so filed by the appellant in the said appeal, being titled Appeal Number 22/2014. The learned the registry shall send the records in here, taking into account that both the parties are represented. They are directed to appear on 24th of July before the registry shall send the records.
Just one observation, Malad. The other grounds taken in the first appeal will be taken care of, because there is a question of limitation also, that was also not in our favor.
They are only concerned with this. Shall decide the appeal in accordance with law.
Applies for.
Highly. Pet physio also. My lord, in this case, my lord, the respondents filed a suit against me, my lord, stating that I am the defaulter. I am a tenant. I was the tenant of the, my lord, husband of the respondent number 1, and I am a defaulter. And my lord,
Suit? What suit is that? What is this suit?
it's for eviction. My lord.
Rent control?
Rent control.
How is this SAO maintainable?
My lord, no, it's my case is that.
Whatever may be, this way, that way, how is the SAO maintainable? Does an appeal lie in view of Section 8 of the Assam Urban Area Rent Control Act?
Yes, that is there. My lord, revision lines.
Matter is finished.
Oh, my lord, that can be taken care of. My lord.
How?
Look, this remanding the matter to the trials court, my lord. That is the issue, my lord.
Understood. But how are you filing this appeal? When an appeal does not lie against an order passed by the appellate court,
My lord,
in view of the bar under Section 8, how do you
can be converted to my lord.
why?
My lord, because that remand, my lord, under 41, my lord, order 41,
Withdraw,
that is not
file a fresh one, nothing doing. Whole matters.
converted.
What?
Converted.
Absolutely no.
Their first is declaring me as a tenant. Their first is, my lord, declaring me as a tenant, my lord. Your lordship may kindly see their title, my lord, plaint, my lord. That is suit for declaration that the defendant is a defaulter and is a illegal possession and recovery of possession. That is also their prayer. Directly, it cannot be, it is a under rent control act.
What?
Directly, my lord, because he said that I am the illegal possession of that tenant, declaring me as a defaulter, and this further is everything.
Your suit, who is the plaintiff?
I was defended.
You are the defendant.
I was-
What is your suit for?
Well, suit was, he was a defaulter since 2003, he was not paying.
Tenant,
rent.
urban area?
Lakhimpur town.
I disputed, my lord, this, I was the, my lord, purchaser of the land, and I have, before, my lord, executed the sale receipt also. And this,
So you deny his ownership?
yes. That was
And
the
he claimed
cross issue.
otherwise,
That was a cross issue.
otherwise he's claiming that his property is purchased by unregistered deed. And
No, no, but he denied your title.
Yes.
Does he deny your title?
I'm not tenant. I'm not tenant. I'm a purchaser of this property, and that sale deed was not registered. Since, my lord, I'm a possessor of my lord, that property, my lord, I'm protected under section 53 of the Transport Property Act. And that was a cross issue, my lord. And the learned trial court came to the finding that there is no relationship between landlord and tenant. So this suit was dismissed. But regarding issue number 5, it was framed that whether I am the owner of the suit property or not, the trial court came to the finding that since it was not registered, so that issue cannot be decided in his favor. There is no counterclaim. But the thing is that that issue was subsequently, my lord, trial court substituted that since, my lord, I am the occupant of the suit premises, I am protected under the section 53 of the Transport Property Act. My lord, that's why I have to file an appeal.
for that.
That I have to file an appeal before the trial court, against that finding. And
But there is no issue for that
yes,
53A.
issue was not decided.
This was there.
Where?
Yes, your lord.
Issue was not decided, my lord.
Where is the issue?
Issue, my lord, that is issue 5.
My lord,
Initially,
page 21,
Number 5.
that was subsequently, my lord, substituted.
another issue.
That was substituted, my lord.
Okay,
That was
whether the
substituted.
defendant being the occupant of the, being protected under the law apart performance.
Yes, your lord.
Now,
Now that regarding that issue, my lord, he failed to, my lord, give the finding that all the evidence on materials is there before the Planet Court, trial court, else appellate court could have decided the issue, my lord. Instead, my lord, issue number 5 has remanded back and said,
why?
he said that no, it was not decided properly, so it has to be decided fresh.
Where,
And-
where?
Your lordship may kindly see, my lord.
Turn and page.
Yes, your lordship.
Paragraph,
Starting from page 36, my lord,
paragraph.
paragraph 12.
Huh?
Paragraph 12, page 36, internal paragraph 12, page 36, your lordship.
Yes.
My lord, may I read? Before proceeding further, one of the disturbing factors that was brought into notice of the court is relating not discuss on a newly substantive issue in the judgment of the learned trial court as the perusal of the records revealed that learned trial court has substituted issue number 5 relating to whether the defendant being the occupant of the suit proceeding
When was the substitution made?
after the my lord, during
Oh,
the-
recent, thereafter the evidence was given.
Yes, yes. Rather, the learned trial court had been discussion related to the earlier issue as to whether the defendant being the purchaser of suit premises became the owner of the same. Moreover, the trial court, without giving an opportunity hearing to the parties on the newly substituted issue, hard argument and disposed of the suit by the impugned judgment and decree. In this regard, we can very well say that the framing of issues probably most important part of the trial and duty of the court. In this regard, the frame has to be researched because it has to be tried in a suit and it has to be give notice to the parties to lead evidence with regard to this frame. Rule 5 of the suit empowers the court to amend issues of frame, my lord, that is there, that has been, and ultimately that it is said that it has to be remanded back for first trial.
No, when was the issue number 5 framed?
After
Substitute.
leading the evidence, my lord, that is there. But all the materials, my
Here
lord,
he
were
says
placed.
that paragraph number 12,
Yes.
the second page, turn in page 6.
Yes.
However, subsequently, issue number 5 was substituted by the learned trial court and thereafter, without giving any opportunity to the parties to adduce evidence in respect of the substituted issue, has disposed of by delivering the judgment.
But that sale deed is already there. I have exhibited. On.
No, no, no. When was this issue framed? That is my specific
Issue was
question.
framed, my lord, later on.
When?
My lord,
Was it at the time of delivery of
I'm
judgment?
giving you the date, your lordship.
This is my lord on,
The Monto
this
at
is
what
on
time?
29/5/2015, my lord.
Huh?
29/5/2015.
Hey, record to sir.
Yes, 29/5/2015. This was framed.
Monto kato. I let you know.
And that too on the prayer of the defendant.
29/5.
29/5/2015 on the prayer of the defendant.
And 5:15. Issue. No. That is why I asked
Yes.
you.
That is right.
It is on 29/5/2015. Earlier it was fixed for arguments.
Yes.
And
Yes,
thereafter it fixed for
Yes,
judgment. Then where is the question? Where is the evidence? Rightly passed.
But along with this issue number 5, issue number 3 also remanded back, my lord. Regarding
Whatever
that,
may
I
be,
was-
all these things
all
will
these
have to be
It's not only
properly
that,
done.
entire
now.
matter has
My
been
lord,
given.
There's no
issue
question
number
now.
3, how it can be, my lord, decided afresh, my lord. All because issue number 3, your lordship may kindly see, page 21.
This
number
court is
3.
not going to look into all this.
Whether my lord, I am the tenant, I was the tenant. in
Mr.
respect of
Sharma,
this-
anything more? There is an avenue available in Delhi. Okay? Chalo, let me decide. The two appeals?
Yes,
Why
my
they
lord.
have to
I
appeal?
also preferred appeal, my lord.
This was before appeal.
I also
Yes,
preferred,
suit
he
was
also
dismissed.
preferred.
Your suit was dismissed, so
Dismissed,
you
so I
prepared.
preferred.
And why did he
I
prefer?
guess about issue number 5.
Number 5.
Issue number 5 was,
His issue number, did he have a counterclaim?
no,
Counterclaim, no counterclaim. That is
Then-
also fighting.
Huh?
No counterclaim. Simply saying, my lord, that.
No, but issue number 5, in fact, it could have been by way of a cross appeal. There's only one suit.
my challenge is only issue number 3, my lord. It was also remanded back, my lord.
There's issue number 3.
3, your lordship may kindly see page 21. Whether the defendant was the tenant of Mohinder Law's Sandok, the husband of the plaintiff number 1 and the father of
So
the
this is
plaintiff.
connected with issue number 5.
But all the evidence was weak, my lord.
How
in respect of-
do you mean that the trial court, first appellate court should have decided that and again remanded it? Tenant, once it is tenant, it is held by him as tenant. Can you remand 5?
Money received.
Mr. Sharma, can you remand it to 5 and ask them, okay, go now see as to whether he has a right under 53A. 53A is completely contrary to tenancy. Then,
That is there.
so if 3 is decided in your favor, in his favor,
Burden lies on him, my lord. There.
now understood. If 3 is decided in his favor, can 5 be remanded?
Definitely not, my lord.
So,
But, because he has not filed anything, because whether
Okay,
he
okay,
can
okay.
file any
this
further.
is
my
an
lord.
unnecessary litigation you have filed.
No, my lord.
So we impose cost.
No, my lord.
No, no, enough.
No, my
Cost.
lord.
How much? How many years it has been pending? 2017. 7 years. 7 years you have lost your right to a victim,
Oh, my lord.
his rent.
He will.
What is this area?
He's failed to establish, my lord. He did not, my lord, exhibit
This
any.
area is how
receipt, my
much?
lord. Any
It's a
rent
house?
receipt.
It's a house? It's a house, Mahanta?
I have paid 1 lakh
It is a one
25,000.
shop room, my lord, one small shop room, my lord.
So you otherwise would have been able to get rent?
Yes, man. Definitely. I was my father and my husband, my lord. He was the landlord and it was paid as per the very well. So after his dying, everything is cooked up, my lord. This is the problem.
Oh. So
No,
for 7 years, 20,000 each, 1,40,000.
my lord. My lord, he
Okay,
did not,
this
my
is an appeal under Order 43, Rule 1U of the Code of Civil Procedure, 1908, challenging the order dated 6/4/2017, passed by the learned district judge Lakhimpur at North Lakhimpur, whereby the judgment and decree dated 17/11/2015, passed in title suit number 15/2013, was set aside. And the learned trial court, that is the court of the civil judge Lakhimpur and North Lakhimpur, was directed to decide afresh the suit, and more particularly issue number 3 and issue number 5. This court duly takes note of the records of title suit number 15/2013, wherein it is seen that the suit was fixed on 13/2/2015 for arguments. Thereupon, after 2, 3, 4 adjournments taken, an application was filed for the purpose of substituting the issue number 5. And accordingly, the issue number 5 was substituted on 29/5/2015, thereby fixing 24/6/2015 for arguments. Subsequent thereto, after hearing the arguments, the judgment and decree was passed on 17/11/2015. At this stage, this court finds it relevant to take note of that initially the issue number 5 was whether the defendant, being the purchaser of the suit premises, became the owner of the same. The substituted issue is as to whether the defendant, being the occupant of the suit proceedings, be protected under the law of part performance. Under such circumstances, in the opinion of this court, the learned First Appellate Court was of the opinion that there would be a necessity for giving an opportunity to the parties to adduce evidence, in as much as the newly substituted issue number 5 relates to Section 53A, the protection under Section 53A of the Transfer of Property Act 1882. Mr. M. Sharma, the learned counsel, submitted that though the learned First Appellate Court ought not to have remanded the suit in toto, but ought to have only remanded by exercising the powers under Order 21, Rule 25, rather than under Order 21, Rule 23A. He submitted that only the issue number 5 ought to have been remanded, not issue number 3. This court takes note of issue number 3, which stipulates that, which relates to as to whether the defendant was the tenant of Mahadev Lal Chandak, the husband of the plaintiff number 1 and the father of the plaintiff number 2 and 3 in respect to the suit premises. It is the opinion of this court that if this issue was decided by the learned First Appellate Court, there would have been no necessity for deciding the issue number 5 at all, in as much as issue number 5. First, under such circumstances, this court finds no infirmity in the order passed by the learned First Appellate Court dated 6/4/2017. Full stop. Taking into account that both parties are before this court, they are directed to appear before the learned court of the which court?
Lakhimpur civil judge,
senior.
and the district judge Lakhimpur.
Civil judge, no,
Oh, yes.
Civil judge
sorry,
Lakhimpur.
Yes, madam.
At North Lakhimpur on 24th of July 2024. The registry shall the registry to record se kort puche. वो लिखे हुए थे appeal is- If the parties are directed to appear before. Yes, madam.
This matter, we have been engaged yesterday only by
Who?
ASTC. ASTC is the appellant lordship and we have been engaged yesterday only lordship.
Who has engaged you?
Mr. G.
ASTC.
Yes, lordship. Mr. G. N. Sahewala is the standing counsel of ASTC and yesterday evening only we have got the information. We have not got the file also till now.
So what is wrong with the order?
The file lordship.
Don't have the file, don't, I will put it at non-appears for the petitioner, appellant.
So we have received an
Dismiss for
electronic
default.
instruction yesterday only. Lordship.
You stand there, I will dismiss your appeal. There's no right. The thing is, the issue is, the general manager ASTC was made a party in the suit. It should have been the managing director. And the learned trial court did not decide the other issues. So what is wrong with it? Don't come up with all these excuses. You know, there was a long list given. Chalo. we
Lordship, in
dispose
that
it.
case, when the order needs to be passed, it can
Huh?
be in presence of my senior lordship.
Who is your senior?
Mr. G. N. Sahewala.
Where is he?
I'll call him.
Okay, ask him to come.
Obliged.
It please your loss.
Hmm.
This appeal is against the order of the learned law appellate court, my lord.
Mhm.
Whereby it was remanded back to the trial court. I beg to draw your lordship attention to page 46, my lord. Question of issue number 3.
Yes. What is there to remand? They could have, the moment the report is being given, you're there. Mister, What is there to remand? When a report is given before the learned trial court, in view of Order 26, Rule 10(1), it automatically becomes evidence,
Yes, Lord.
isn't it? Now, if the trial court did not consider that, why didn't the first appellate court consider it?
Because Lordship, the report was itself available with the trial court, Lordship. But the rejection of the trial court, the report was simply rejected, Lordship, without discussing that why it was rejected. So now, Lordship, the report of the expert is very much essential because on his own request, Lordship, the report was called for, Lordship. Expert.
If it is a rejection, it is a rejection under Order 26, Rule 10(3).
Yes, sir.
If it is so, either you could have very well asked for an application that you want to give a further report, or you should have asked for cross-examination. You should have challenged the report. The challenge is rejection. You challenge the rejection.
No, no, Lordship.
Then
Because,
how do I help you?
because that report was, Lordship, called for on. his
No, what
request.
does the learned first appellate court? You see that whether it is, you see, Mr. Counsel, a report cannot be rejected. It always becomes a part of the evidence. Whether it is appreciated or not is a question.
Yes.
The learned trial court did not appreciate, the first appellate court could have. Isn't it the judgment in the Silchar Municipal Board? Justice Bhatt's judgment. Then let the first appellate court look into the report. If it deems fit, let it pass the judgment. If it does not, matter ends.
Yes, sir. So let the first appellate court may decide.
Yes. No question of remanding.
Remand.
Anything, Mr. Amit Rajbol?
My lord, then the first appeal ought would have done it, my lord, but it seems if the plaintiff would make an application,
No. See, a report becomes a piece of an evidence
evidence, my lord.
in view of Order 26, Rule 10(1). If it becomes a piece of his evidence, you cannot do anything with that. The report always remains.
But from the
It is the
plaintiff side,
question of appreciation or not appreciation. If
But then-
somebody is aggrieved with the report, he or she can very well say that kindly I want to cross-examine the witness, the expert person, or the court may, if you see Order 26, Rule 10(3), the court may call for further report. But you can't reject that report. It becomes a piece of evidence.
and then for no application from the plaintiff appellant side, my lord, that the report that has been come, he did not make any application. He did not approach the court that it ought to have been done.
Mr. Whether the report is kindly see, you have the CPC?
Yes.
See Order 26, Rule 10. 1. Yes, what does it say?
Commissioner, after first local inspection as it deems necessary, and after reducing to writing, the evidence taken by him shall return such evidence together with the report in writing signed by him to the court.
Then 2, the report of the
the report
commissioner and the
and the
evidence
commission
taken by him,
to
but
the
not the
evidence in
evidence
suit.
without, there shall be evidence in the suit
The report of the commissioner.
and shall
the
form a
evidence
part of the
taken by him
record. But the court, or with the permission of the court, any of the parties to the suit may examine the commissioner touching on the matter so and so, or report or here. Where the court is for any reason dissatisfied with the proceedings of the commissioner, it may direct such further inquiry to be made so and so. So under such circumstance, it becomes a piece of evidence. It now depends on the appreciation as to whether the trial court appreciated it properly or not. If it is not being done, the first appellate court will do. Matter ends. Report is in your favor.
No, report is not in my favor.
So why did you file the appeal?
My lord, he filed the appeal before the lower appellate court.
Here, who filed the appeal?
Myself,
Why did you file the appeal? There you could have very well challenged the appeal. Once it is remanded back, you can very well challenge it, the report, and exercise the powers under Order 26, Rule 10(2), and go for cross-examination, the dissatisfaction, there may be another report.
of course, he could have done it, my lord.
But filing the appeal out here, you have to cause a disastrous thing for yourself. Now he'll be happy, well. You have done favor to him. It was some matter like yesterday, when there was a judgment being passed wherein there is a direction of specific performance and also said in the alternative he will pay this. And I told the counsel out there, if you file this appeal and if I admit it, the other side will just come up with a cross objection and matter is finished. He will just say that this order should not be passed. You still have the opportunity.
My lord, my question before the law, submission before the lawsuit, the report was in his favor. The handwriting expert report was in favor of the appellant. So was it not his duty to make it approach the court below? Or for calling the.
Who's appealing? Your? His favor. Yes.
The report came in his favor, my lord. So was it not his duty to call the handwriting expert for examination?
Why? It is in his favor. It is for you to ask for that.
He is the plaintiff, my lord.
Understood. The report is in his favor. Why? Why will it touch on the report? It is evidence. It is for you who is dissatisfied. Because it becomes a piece of evidence.
And that apart, my lord, your lordship, the learned law appellate court, your lordship, if you read the paragraph for page 47, my lord, he has appreciated the evidence which was appreciated by the learned trial court while dismissing the stand of the plaintiff. The learned appellate court also considered this thing, but he find fault with
Mr. The moment you are challenging this order, do you know the consequence? The consequence is this matter again goes back to the learned first appellate court. I can't decide anything more than that. If it goes back, you are in more difficulty. It should have been in your interest that the matter goes back so that then you can pinpoint on the report. Challenge the report. We interfere with this order. As you have come all the way. You may be happy winning a small semi-final, what do you call a league match.
For the sufficient question was framed by the bottom of court, my this court is that he could have done it. He failed to do it.
Mr. The question of substantial question of law will arise when? If it's an appeal under section 100. 100 only says about substantial question of law. Does 104 say so? 104 is absolutely, it's an appeal. It's a miscellaneous appeal. And therefore you have come under order 43, rule 1R, 1U. Then we don't want much to say when we are in live streaming that in an 104 appeal, this court has framed substantial question of law, portrays a very poor picture. And we don't embarrass or shame us. What to do?
Give it before the lawsuit.
Oh. This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure 1908, whereby the order dated 31/3/2017 passed by the learned District Judge Hailakandi in Money Appeal number 1/2015 has been put to challenge on the ground by the impugned order. The learned First Appellate Court had remanded the suit back to the learned court of the civil judge Hailakandi remanded the suit being money suit number 05/2010 to the court of the civil judge Hailakandi, that is the learned trial court, for deciding the suit afresh. This court have duly perused the order, impugned order. And from a perusal of the impugned order, it is seen that the learned First Appellate Court had remanded the said appeal solely on the ground that the learned First Trial Court did not take into account the opinion of the expert opinion. At this stage, this court finds it very relevant to take note of the provisions of Order 26, Rule 10, which categorically mentions that the report of the expert, along with the evidence, would be evidence in the suit. If it is an evidence, if the expert opinions is the evidence, this court finds no reason why the First Appellate Court would not have exercised its jurisdiction to appreciate the expert opinion by itself, rather than remanding the suit back to the learned trial court. This, in the opinion of this court, is contrary to the provisions of Order 41, Rule 24 of the Code. Accordingly, the instant appeal is allowed by setting aside the order dated 31/3/2017 and thereby directing the learned District Judge Hailakandi, that is the First Appellate Court, to decide the said appeal, being Money Appeal number 1/2015 in accordance with law on merits. By parties are represented 24/7. Winning a league match, losing the semi-final. It's something like Pakistan did not even go into the World Cup Group 8, something.
Of course, while appreciating this one, the learned trial court, appellate court will consider the entire materials of the other part, because
I've
he
said on
himself
merit,
has got to the
on
matter.
merits everything, but you have the big problem. You should not have filed this appeal. Else your return hebus of delivery. Your return special messenger hebus. Yes, Mr. Sahibullah. What is wrong with the order?
Well, the exact matter I have not gone through it. Matter just now, Amit Sahela, was about this file, whether he is guilty.
There's nothing wrong with this order. You see, it was the general manager ASTC.
No, not general manager. Everybody has not been made a party.
Huh?
Everybody ASTC. That was not a made a party.
Oh, rightly done now.
Then Malad that one gender messy party.
Oh, it is there. You should not press the appeal. Let it go.
But the.
You want a dismissal?
Not press the appeal, not Malad.
Okay. Heard Mr. G. N. Shaivalan, the learned counsel, appearing on behalf of the appellant, assisted by Ms. Estodi, the learned counsel. This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure 1908, challenging the order dated 21/3/2017, whereby the learned civil judge number 3, learned first appellate court, that is the court of the civil judge number 3, Kamrup Metro at Guwahati, had remanded the suit back to the learned Munsif number 1. The suit being title suit number 665/2006 to the learned Munsif number 1 by setting aside the judgment and decree dated 3/11/2009. This court had duly taken note of the impugned order and finds no infirmity in the said order. Consequently, the instant appeal stands dismissed. The parties herein are directed to appear before the learned trial court that is the court of the Munsif number 1, on 26th of July 2024. The trial court shall decide the said suit in accordance with the directions so passed by the learned first appellate court dated 21/3/2017, passed in Manik title appeal number 15/2010. So the registry shall send the records back so and so and so.
Order on rule, they do, my lord, and a power they had corrected. But just now, my lord,
That's okay, but I am also seeing it just now. I've never seen the file. These matters, in fact, therefore I've asked them to list all these SAOs. These SAOs are like CRP IOs, which needs to be finished as soon. Because you are staying a suit. Suit or appeal proceedings have been stayed, and I'm starting today from 2009 SAO.
11.
Yes.
This SAO was not filed by us initially, filed by not we. Lordship, here it contains only the impugned judgment of the learned first appellate court without the judgment of the learned trial court and plaintiff WS. However, the record was called for, record has come. So I have a problem of looking into the judgment of the learned trial court as well as plain WS. A day may be given so that we can correct these three documents,
What?
because the SO does not contain the judgment of the learned trial court as well as plain and WS.
Contains.
No.
What is the order passed in the SAO?
Only the impugned judgment has been
Impugned judgment only.
enclosed.
It is only for the purpose of the document. So the appellate court could have done it.
Yes.
Then you file an application. Do you file an application under 41/27?
That I don't think that that application also was allowed to be filed before the trial court.
Who filed?
What are 41/27 petition?
You filed there.
Yes.
That was not decided.
Not decided.
So the appellate court could have decided that,
Yes.
and it is only the rectification did.
Yes.
But the rectification did, actually, it was, the problem is that rectification did. After we purchased in the year 2002, rectification was soon to be purchased in the year, done in the year 2003, whereas his original sale deed was in 1998. Therefore, the foul play was there, and the parties are not there. Parties, those persons from whom they purchased and we purchased, they were not made purchase. They were common parties, common ancestors.
He could not produce the said document. What do you
We have-
call the rectification deed? The trial court, first appellate court could have very well taken up the rectification deed in terms with order 41 rule 27. Instead of remanding it, he set aside this order and direct the learned first appellate court to decide it. The instant appeal is filed under order 43 rule 1U of the Code of Civil Procedure 1908, challenging the order dated 12/6/2017 passed in title appeal number 33 of 2008, whereby the learned first appellate court had remanded the suit being titled suit number 446 of 2006 back to the learned, back to the
Trial
court of the
Munsif one.
learned Munsif number 1, Kamrup Metro at Guwahati. For deciding afresh thereby also allowing the appellant, who is the plaintiff, to produce the original of the rectification deed and the family settlement of the partition deed by calling its original one for determination of the correct location of the boundaries of the suit land of the appellant. This court had duly heard the learned counsels appearing on behalf of the parties and have given due anxious consideration to the same. It is seen that the learned first appellate court have allowed the application under order 41 rule 27 of the code, thereby permitting the appellant to produce the original of the rectification deed and the family settlement oblique partition deed by calling its original one for determination of the correct location of the boundaries of the suit land of the appellant. If that be so, it is this court fails to understand why the learned first appellate court did not decide the said appeal rather than remanding the appeal back to the learned trial court. Inasmuch as the first appellate court, being the last court of facts, could have very well decided the said appeal on the basis of the other evidence, including the evidence which have been permitted in terms with order 41 rule 27 of the code. Accordingly, this court interferes with the order dated 12/6/2017 passed in title appeal number 33 of 2008 and directs the learned first appellate court to decide the suit appeal being title appeal number 33 of 08 on its merits on the basis of the evidence, including the evidence so permitted in terms with order 41 rule 27. In that regard, opportunity may be given in view of the order dated 12/6/2017 to the appellant to call for the original of the rectification deed and the family settlement oblique partition deed from the
defendant. Or,
How can it be?
not from them, from the
plaintiff,
is it a registered document
registered.
That
from the sub
Oh,
registry?
unregistered. So family settlement was unregistered.
rectification is registered one,
Yes.
as regards to the family settlement, I do not know.
Thereby permitting the appellant to produce the original of the rectification deed and the family settlement oblique partition deed in the manner so permissible under law. The appeal therefore stands allowed in view of the above observations. and taking into account the parties are duly represented, they are directed to appear before the learned First Appellate Court, that is the Court of so-and-so, on 29th of July 2024. LCR Review returns it on
Lordship,
police.
Dispute is regarding boundaries. Kindly allow us to file application for Amin Commission.
You file whatever you like. I'm not unconcerned. I'm not here to give you. Not in this lifetime.
May PG Lordship. Who I for my lord, for substitution of respondent number 4, my lord.
Hmm?
For a substitution of legal heirs of respondent number 4, my lord. 1 and 4 died, my lord.
The number 1 and 4 had expired, my lord, and I had brought it to the notice of the court. And in place of 1, my lord, all the other legal heirs are already there on record. But then respondent number 4 had also expired, my lord, and he has filed his petition for substitution, my lord. I don't have any objection to that, my lord. But then, my lord, notice has to go to the, my lord, legal heirs now who will be implemented, my lord.
In the morning, my lord, I have been informed that respondent number 3 has also died, my lord. But I'm not sure about the date, my lord. Yes, sir. Thank you, my lord.
Respondents have died. If I dismiss his appeal, matter wins. Yes. Now come to the case.
My lord. My lord, I have filed a.
I can't pass an order against the dead person. I can pass an order against an appellant who is alive.
I'm also agree, my lord, with this pendency, my lord.
Let's
Because,
see.
my lord, I filed a suit against the respondents.
Where is
1,
that
2, and
order?
3, my lord.
Where is the order?
Interim order is, my lord. Page 30, my lord. The order 9 rule 13 application has been initially, my lord, dismissed, my lord. They preferred an appeal, my lord. In appeal, my lord, that has been reversed, my lord. In the execution stage, my lord, they have filed an application for order 9 rule 13 application, my lord. What has happened in this?
No,
case?
no. An ex parte judgment was passed.
Pass, my lord.
Against that, you filed an appeal.
No, my lord. Ex
You
parte-
filed an order 9 rule 13.
I was the plaintiff of the suit, my lord. Ex parte judgment and decree was passed, my lord. Thereafter, I have filed an execution, my lord. By the executing court, my lord, the sale deed has also been executed. I have deposited the amount and notice was served to the respondent, my lord. Then, my lord, they have come, my lord, with an application under order 9 rule 13, my lord. That application has been rejected, my lord. Thereafter, they have preferred an appeal before the additional district judge, my lord. That has been allowed, my lord. Against that, my lord, I have preferred this, my lord, as you, my lord.
Now, what does section 104(2) says of the CPC?
And 4, my lord. Appeal shall lie from the following orders and save as otherwise expressly provided in the body of this court or by any law for the time being in force from no other orders. An order under section 235A, an order under
That is okay. Then thereafter,
thereafter any other order, my lord. Any other order
no, thereafter.
thereafter provided that no appeal shall lie against any order specified in clause F, save on the ground that no order or an order for payment of a less amount ought to have been made, man.
Two. No
Well,
appeal
no-
shall lie from an order passed in an appeal under this section. So they filed an appeal against an application by which order 9 rule 13 was dismissed. That appeal was allowed. Once it is being allowed, how do you file an appeal against that? How? Can't file an appeal against that.
My lord, under order 41, my lord, it's an appealable order, my lord, order 9 rule 13, my lord.
They have already preferred an appeal
My lord, that's
under
why, my
order
lord,
43, rule 1C or C, I suppose.
my lord, that.
And
that's why, my
against
lord,
that, there is no appeal. There's no appeal lies against that.
Humble understand that, my lord, since it was an order of appeal, my lord. So I have to file an SAO, my lord.
How do you file in view of 104(2)? Oh. An appeal filed against the order dated. An appeal filed against an order dated 21/12/2018. Passed in Miss Appeal number 03/2018, whereby the application under order 9 rule 13, which was dismissed by the learned trial court, was allowed. Full stop. This court, taking into account the provisions of section 104(2) of the Code of Civil Procedure 1908, which stipulates that no appeal shall lie against an order dated against an order passed in appeal under section passed in an appeal which have already been preferred under section 104 of the code, is of the opinion that the instant appeal is not maintainable. Accordingly, the instant appeal stands dismissed. There's a stay. There's a stay.
Of that order, my lord. I may be granted labor to, my lord, file.
Stop. The impugn order, the order dated 1/4/2019, passed in ISC bill number 1040/2019, is set aside, is vacated. This court further directs the learned trial court to proceed with the disposal of title suit number.
Title suit is already, my lord, title execution case is pending, my lord.
This was allowed, so there was a direction for the suit to proceed. Title suit number
8/2016.
8/2016. Directs the learned trial court, that is the court of the civil judge Sonitpur, Tejpur, to proceed with the disposal of the title suit, being title suit number 8/2016, in terms with the directions so passed by the learned first appellate court, dated in its order dated 21/12/2018, passed in Miss Appeal number 03/2018. Then exposed, LCR returned, accompanied by Lekiribo. Parties are directed to appear before the learned trial court on the date 29th of July 2024.
But
See, and eyes closed.
Lordship, you kindly take up the matter after some time.
Why?
Thanks, Lordship.
What are these matters? SAO. What are these two SAOs? Why two SAOs? But these are new matters.
Sometime he's on vaccine.
Okay. Have it after vacation. I've already done my lot today. The appeal is dismissed.
My lord, they had preferred an application in the.
In
Rule
the title
97.
execution, we have put an application lodged.
What?
Rule 97.
My lord, under order 21, rule 97, they have filed an application before the Munsef. And against that, they prepared an appeal. And
This is a second appeal.
this is a second appeal.
Can't be an RSA, SAO.
Yes, but here in this case, my lord, what happened? I filed a suit for tenancy and for recovery of possession on the ground of defaulter and bona fide requirement. In that suit was decreed in favor of me. In that suit, the appellant herein also filed an application under order 1, rule 10. That was rejected. Against that, they prefer civil revision before this honorable court. The order was upheld by this court. Then suit was decreed. When I put to an execution of the decree, then they filed this application order 21, rule 97.
Then
Order 21, rule 97 was dismissed on the ground that they are claiming title on the basis of unregistered sale deed. Unregistered sale deed. They are claiming that they are the owner of one Shuklavadya. But the court below has held after taking evidence that Shuklavadya has no right to transfer the land, and apart from that, that transfer was made by way of unregistered deed, and I have purchased from the original owner the suit land.
anyways, this has to be registered as an RSA. Can't be an SAO. One. Then the court fee,
Yes. And apart from that,
it's a decree.
my lord,
So under such a, it cannot be an SAO. SAO will be under 104.
but my decree, my lord,
What?
the decree obtained by me is not, I am not been able to execute.
Whether the appellant could establish his possessory right in the premises since 1980, independent of the right of the decree holder, and thereby the decree holder is not entitled to execute the decree. Whether Exhibit 7 issued by Sri so-and-so gives significant right to the appellant to that of the decree holder, and whether the decree holder can execute the decree against the appellant. Whether Iman heard in not taking Exhibit 4, which is a tenancy agreement, although the same was not registered, the same can be considered for parallel read with other documents which. Isn't it the law that if you want to be put under possession under Order 21, Rule 98, or you have, or to nullify a decree, you have to show that you have a better right to be in possession?
No, my lord, I possess. It is my possession, my lord.
What? Not your possession. You
My
are to
independence-
show that you
independence-
have a better right to be in
independent
possession.
My independence, my lord, possession, right.
Huh?
Right and possession.
That is what. So you have to show that you have a better independent right of
Here,
possession.
both the court below, what happened, my lord, they have wrongly, my lord, framed the issue that whether I am a evictable tenant or not. Evictable or not, that is not a question, my lord. That is why, my lord, this honorable court has framed this issue. Whether I have an independent right of. Because here, my lord, what happened, this is a.
There cannot be a possessory right. Well, there is a decree. That was a suit for what? Your suit was for?
Suit was for
Eviction.
eviction. My lord,
Eviction from what? Land?
eviction under Assam Urban Areas Land Control Act.
So landlord tenant.
Landlord tenant.
And he was in possession?
No, that position was in pro forma respondent.
Huh?
Respondent herein,
No, I'm not concerned. He was not in possession.
not possession. That
Then
is
what
why
happened? How
he
did
has
he
also
come?
filed application under Order 1, Rule 10 in earlier suit. That was also rejected. Court, this honorable court also upheld that he has.
No, that is okay, but I'm only asking. Who have not been able to execute the decree, is he in possession?
He is in possession now, because one Shuklavadya has handed over possession to him, and accordingly
Who is Suklobadya? He was the original defendant.
no,
Then?
he was also third party.
So how did Suklobadya get the possession?
Shuklavadya was caretaker. It is shown that Shuklavadya was the caretaker of the pro forma respondent,
Since the original defendant,
original defendant.
caretaker.
Caretaker. And issue was also framed whether decree holder OP number 1 and 2 has right title interest over the decretal property in title suit number so and so. That issue has been favored issue has been decided in favor of me in this case.
And what is his right to be in possession?
He has claimed Maliki right on the basis of unregistered sale deed.
What right?
Maliki right, that means ownership right,
On the basis of?
unregistered deed. That pleading, his specific pleading.
You're Muslim?
What happened? I'm submitting that. Here, a suit has been filed.
That is the only way out.
Yes.
A suit has been filed.
Unregistered deed.
If
Unregistered
your lordship will see, well, police suit has been filed.
Huh?
A police suit has been filed. Well, this was a, well, the Seabed in the original, my lord, originally, Seabed sold the property which has no right, my lord. Each, my lord, the vendor was the person who purchased the Maliki, this ownership from Seabed, who had no right, my lord, to sell the trust property.
But
Now-
have you challenged his title?
No, but because we are not allowed to be arranged a party to the suit.
Forget about that.
Yes.
In this case, under Order 21, Rule 97, did you challenge his title?
We have to, my lord, because our Order 1, Rule 97, my lord, that our independent right, my lord, that has been shown.
No, independent right, okay, but did you challenge his title?
No, title, my lord, cannot challenge it.
You
That
can very well challenge. It is like a suit.
Even then, my lord, here I have to show that my independent right.
Huh?
My independent right, my lord.
No, not merely in independent right. You have a better right to remain in possession,
Yes.
not him.
Yes,
That is it.
because here, my lord, police suit has been filed. If you also see page 14 of the annexure 1, how he has, my lord, got a decree against false name, my lord, he has filed a suit, and that is why we,
Age?
page 14, my lord, annexure 1. I'm sorry, my lord.
Where is the I?
Shankar Das.
And who is
That
this
is number-
Sita Devi Das?
Huh?
Sita Devi is.
My lord, that is another thing. My lord, I'm just placing Shankar Das because that will be, my lord, I'm. Annexure 1, page 14.
I number?
I number, my lord, 805.
805 only. Yes.
My lord, this police suit has been filed against them. It's a false, my lord, person, actually,
Page 19.
page 14.
Huh?
Page 14. Page 14. 1 4.
Page 14 is not that.
Annexure 1, my lord. That is
Yes, that is the order.
order.
Then
This is the order in the suit, my lord, his suit. Plaintiff is defendant is also present. The defendant, high petition number admitted the case of the plaintiff. The prisoner is supported with affidavit. I heard both sides suit is decreed on it.
oh, did I deal with the suit earlier somewhere? I found something like where he duly admitted this.
Yes, my lord.
Okay. So on the first day, degree.
Decreed, my lord. That main question, my lord.
The Congress side was nowhere in, party there, my lord, nowhere in position.
Suit is on admission.
Yes.
But Mr. Saivila, don't
Yes.
you think
Yes.
that when you file an application
Yes.
for under order for 21 rule 97,
Correct.
you are also to ask if there is you are saying that he has no right to declare the non-evictable tenancy right of the petitioner as on so
I'm
and
not
so in
going on.
respect to the scheduled land which is decretal as so and so. Confirmation of possession being holding the decree of a said suit is suitable and binding. Even the so and so have no right else as a lessee or a owner over the land described in the below in the decree.
I assume my person.
We do one thing. Let it be registered. You had a very easy suit. Lifetime in a suit, so it can be delayed. Okay, taking into account that these both appeal, huh? Taking into account the appeals being filed, the instant appeal is against the decree. In as much as arises out of proceedings under Order 21, Rule 97 and 101 of the code. And it is a decree in terms with Rule 103. This court directs the registry to re-register the instant second, re-register the instant appeal as a regular second appeal. And thereupon, records have come. Thereupon, list the matter for hearing on, give a good date. 2021 in the usual course.
Hello, the 2019, I filed execution.
Over.
2009.
Huh?
2009, I filed execution.
2009, you file execution on the date on which you got an admission for on admission.
But in this case, what they are claiming? What they are claiming? If they claim better title than me, then matter would have been different.
Whatever may be,
They
it is a
even-
second, it's a second appeal of
It is-
2021. You have to take it in that regard. Everybody has a different case. Everybody has also a case and emergency. Or you give a date for hearing on. I don't know. I may not be sitting after vacations in this bench.
before vacation. Before vacation.
Absolutely no. It's on 2nd of August, on
Must-
1st of August, 2024.
I hope your lordships will be taken up.
No. I had enough trouble. There are lawyers with this bench. That I hope what order.
My lord, in both the cases.
15. Funny. Yes.
Lordship, this is a simple case of arithmetic.
Huh?
Simple case of arithmetic principle.
Arithmetic.
Actually, plaintiff, respondent as a plaintiff instituted the suit.
Yeah.
Maybe the chief the suit land measuring 10.13 lessa.
Yeah.
Wherein she constructed a some type house, which measurement is 29 feet into 50 feet. But subsequently she said that we have disposes the from 7 lessa oblongs, it will be. After construction of 29 feet into 50 feet, the entire land 14 1453 square feet is over. There is no vacant land. Therefore, the order of remand for allowing a commission by under order 26 rule 9 is a bad one. Learned appellate court should have decided the matter before the
After writing 101 paragraph judgment,
yes.
and he remands it.
Yes. And that too, Schedule A, which is 10.13 lesser, is equivalent to 14.53. And the house construction is also 14.53. So there 14.53, there is no vacant land. So Schedule B land, which they says we have dispossessed her, is a bad one. It could have been judgment passed by the London trial court is a rightly passed. Interference by the appellate court should not have been there.
I'm not going on that merits. I'm only concerned as to whether it should have been remanded.
And that too, appointing a commission.
Or whether it should have been remanded.
No, it was not required.
So the appellate court could have decided that.
Yes, Lordship. All the materials were there.
During the trial, member.
Huh?
During the trial, no demarcation was, no application for demarcation was filed for any court.
What was the suit for?
For recovery of past possession declaration. Declaration of right to real interest and recovery of past possession.
Then
Trial court dismissed the suit.
Trial court dismissed the suit and we have filed appeal, member,
suit for recovery of
past possession
and right titling deeds.
and declaration.
The suit was dismissed. Means that you filed an appeal.
Appeal,
An appeal,
in the appeal,
the judgment of the learned trial court was set aside
that is it.
and then
Remanded the
remanded back.
The limited issue, member.
Why?
This was 71, my lord. Past year. There are 98.
Decide the suit afresh,
Afresh.
limited to the issue as to whether the defendant are in illegal occupation of the Schedule B land.
Yes.
Why the first appellate court could not have done it by themselves? Now, the instant appeal is directed against the order dated 5th of January 2021, passed in title appeal number 10/2018, whereby the learned first appellate court remanded the suit, being title suit number 60/2014, to the learned trial court, that is the court of the civil judge Jorhat, to decide the suit afresh, limited to the issue as to whether the respondent/the defendants were in illegal occupation of the Schedule B property, and in that regard, directed the learned trial court to appoint a commissioner for the purpose of demarcation as well as measurement of the suit land, whether through an advocate, suit land through an advocate, commissioner, or an officer of the revenue department. It was also mentioned that all other issues will not be open for determination. This court have duly heard the learned counsels appearing on behalf of the parties and have given due anxious consideration to the respective submissions. This court fails to understand as to why the learned first appellate court, having decided all other issues, did not decide the said issue, inasmuch as if the learned first appellate court was of the opinion that for the purpose of deciding as to whether the respondent oblique the defendants were in illegal occupation of the Schedule B land, the learned first appellate court would have decided the same on the basis of the evidence on record. It was also open to the learned first appellate court to employ the provisions of Order 29 Rule, Order 26 Rule 9 of the code. If it deemed fit that there was a Order 26 Rule 9 of the code, if it deemed fit as that there was a necessity of appointment of a commission in terms by appointing an advocate commissioner or an officer of the revenue department. The same having not been done in the opinion of this court, infringes upon the provision of Order 41, Rule 24 of the code, for which this court interferes with the order passed by the order dated 5/1/2021, passed by the learned court of the Additional District Judge Jorhat, entitled Appeal Number 10/2018. This court further directs the learned first appellate court, this court allowing the instant appeal, which only challenges the order of remand, directs the learned first appellate court to decide the said appeal on its merits, and if necessary, would be at liberty to would be within its powers to exercise the powers under Order 26 Rule 9, if so deemed fit. With the above, the instant appeal stands disposed of, thereby directing the parties herein who are duly represented to appear before the learned first appellate court, that is the court of so-and-so, on 1st of August 2024. The records, so produce, baki records ke likhenge. See.
My senior Mr. My senior Mr. Bisidash was ready to
Your senior, what has happened?
do the case, but he's not feeling well and he has handed over the file to me just now.
Who is your senior?
Mr. Bijan Chandra Das.
Bijan Chandra Das. Where is he? You have been taking time all along? 1, 2,
So let me give me
3, 4,
get the case.
5, 6, 7, 8, 12, 13.
Your Lordship fixed it on Monday. I will do the case because I have not prepared in that manner because I was under impression that my senior will do the case.
No. You do the case.
I will
Properly prepare.
No, I will.
We'll have it in the month of November.
No, Your Lordship,
It's a weather is cool.
no, Your
Better.
Lordship, give
We
me
will
one
have
day time,
a
one day time.
less humidity, less water logging problem area.
Your Lordship,
Let's fix it on
Your
4th
Lordship,
of
give me
November.
one day time.
Absolutely no. This can't happen. I'll impose cost upon you. This can't happen like this. You can't take time. And every time you are appearing.
No, I am.
Yes, last only also. Last time you appeared, who is Mr. S. Paul?
Police.
He was appearing all along. Then This can't happen like this.
Your lordship, to fix it in tomorrow, I will do the case. then.
First of all, you get a notice issued in a second appeal, which is more. It is seen that the petitioner appellant have taken adjournments time and again in the matter on the ground of the senior counsel. Under such circumstances, for the ends of justice, this court grants an adjournment to be listed and thereby fixes the instant appeal on 4th of November 2024. It is made clear that on that date, if the appellant seeks for an adjournment, this court will presume that the appellant is not interested in pursuing with the appeal.
4th November.
4th of November. Is a stay?
No,
Very well. Yes, what is this? Oh, this matter. We have asked the government, the union to also appear. You're appearing? Oh, Miss Phukan, you're appearing?
Yes, your lordship.
And where is the lady who was the main?
D5, yeah, your lordship.
Yes, where is she? We do one thing, we fix it. This matter has a lot of ramifications.
Yes.
As to whether the provisions of Hindu Succession Act, Marriage Act, which can be applied in the case of under those scheduled tribes under 366(25).
In view of the legal formal under section 2, subsection 2 of the Hindu marriage.
What do you have to say?
Yes, sir, I have to take instruction, your lordship.
Huh?
I have to take instruction, your lordship.
You have the instructions? Yes, what is your instructions?
Right now, I don't have, your lordship. Last occasion, no direction was there to the central government. First time I was appeared.
Yes, your matter. And the union, and who is appearing for the Assam, state of Assam?
RM Das was there, your lordship.
Where is he?
I think he is not aware of the matter because his name has not been shown and my name also has not been shown yet.
Don't. Okay.
Only yesterday it has been filed, Lordship, in the CIS system. It has been updated only yesterday, Lordship.
You file later?
Yes.
We vacate the stay. We vacate the stay. We asked you to do it within a week.
সেইটো কাৰণে সেইটো CIS system ত দিয়া নাই যে নামটো reflect কৰা নাই। Lordship, I have been informed that even extra copies have not been served.
I have supplied all the copies, madam.
I am vacating the interim order. The matter, it is seen that this court, by an order dated 24/5/2024, had directed the counsel for the petitioner to take steps upon the newly imputed respondents by serving extra copies of the petition. However, till date, no steps have been taken in that regard. It has also been brought to the notice of this court that a fresh memo of parties was filed very recently, and as such, it was only uploaded in the CIS yesterday. Under such circumstances, this court would not like to further keep this matter as part heard. In addition to this court also vacates the interim order.
He obliged, Lordship.
List the matter after vacations.
Lordship, can a date be fixed?
After vacations.
Your
Deeply
lordship,
obliged.
I vacated the stay order,
Deeply
so you
obliged, Lordship.
proceed with the suit.
your lordship, name of CGSC maybe.
Huh?
Name of CGC and state government maybe is reflected in it also.
The registry shall show the name of Ms. Kie Phukan as well as Mr. R.M. Das, appearing on behalf of the state of Assam, the Union of India, and the state of Assam respectively.
Deeply obliged.
Yes, what is this?
Just because that matter which I wanted to convert it into a writ petition
Ah,
because order is assent against the order of revenue board.
then what happened? You want to convert it?
Actually, last occasion your lordship opined that your lordship will send back the matter because very cryptic order has been passed.
Oh, yes. Which order?
At page,
Where is that order?
at page 29, my lord.
So, your basic contention is the sale has been set aside. Is it your case?
Actually, our case is that they have not obtained the sale certificate. my lord.
Forget about that. Whether there is a sale. Whether there is a sale.
There are documents, my lord, which suggest that
No suggestion. Sale has to be set aside. As per this is under the Assam Land and Revenue. 74.
74.
Click on the auction, Assam Land and Revenue. Sale by whom and when to make and how it is the sale to be set aside. To set aside it has to be done under 79 at any time a month to set aside the sale on the ground of some material error or mistake, provided no sale shall be set aside here. So there has to be an order passed by the Deputy Commissioner. Has the Deputy Commissioner any order passed any order setting aside the sale?
my lord, 85.
Huh?
85.
85.
Yeah.
85. On sale becoming final to be put on possession. Then
After the sale has become final, the deputy commissioner shall put the petitioner purchaser into possession of the property sold and shall grant him a certificate to that effect that he has purchased the property to which the certificate refers. 2. The certificate shall be so and so, nothing. 3, my lord.
it's okay. This is subsequent there. But the sale being not set aside. It is something like you getting a certified copy after a deed of sale or getting the original deed of sale from the registry. Nothing more than that.
A certificate granted to a purchaser under this section shall be conclusive evidence in his favor. That evidence is not there. That is my ground. And my
No,
lord,
that is not down now. There is a sale. Whether a sale has taken place or not, you admit there has been a sale.
there was, my lord.
And did you show any document to show that the sale was set aside?
My lord.
Then
There are documents, my lord.
only document is 79, order of the Deputy Commissioner. Where's the order of the Deputy Commissioner? Cannot be any other order. I must have said on the last occasion, why should we transpose this matter or convert this matter under 226? Because the order seems to be right. By way of a cryptic order itself, I can dismiss your petition.
So that we fix, I'll place, my lord. Because
What?
for hearing, my lord. For hearing. For hearing, a date will fix.
Today is for hearing.
Next week.
You know
Next
it
week,
is
any
our
day.
summer
Monday,
vacations.
Tuesday, any day, without. Any day.
Then,
I will place my arguments without.
okay, then we do one thing, we convert it.
Yes.
You filed an application.
Yes.
IA condition. Which is the IA?
886.
1462.
886. without.
Huh?
886. 24.
3696.
IA 886.
No, it is 3696. Oh, 3696. This is an application filed for conversion of the instant revision application to a writ petition under Article 226 of the Constitution. Inasmuch as it is a case of a petitioner that on account of a mistaken advice, the application was filed under section 115 of the code. Was taking into account that the materials on taking into account the materials on a record and also the order which have been impugned, it is the opinion of this court that the petitioner ought to have filed an application under Article 226 of the Constitution rather than filing an application under 115 of the code. Accordingly, for the ends of justice, this court converts the instant proceedings to a proceedings under Article 226 of the Constitution. The counsel for the petitioner is directed to file an additional copy of the pleadings exchange.
Yes, my lord, right.
So
At the time
directed to file a set of the entire pleadings of the instant proceedings before the registry within 3 days from today. The registry shall, on the basis of filing the pleadings, shall convert the instant proceedings to a proceedings under Article 226 of the Constitution. List the matter immediately after the vacations. I hate to, that is illegal. Econ petition one not go that so after conversion, the matter be listed before the appropriate bench immediately after vacation.
My lord,
I
I want to point out one thing, my lord. In this case, my lord, as it is 226, I can file, my lord, affidavit in opposition, my lord. Because at the time of 227, I have not filed, just file objection in the
Mr. H does. The matter would not come up before me. You are at liberty to file whatever you like. And in the meantime, you know, he's not changing his pleadings.
Yes.
So under such circumstances, if you want to file it.
I will ask.
I can dispose. Yes. Item 18.
I thought there was one on the stream, I'm opposing one of this.
Yes, Mr. Mazumdar.
Yes, my lord. I'm sorry, my lord, I couldn't appear physically. under certain
Outstation
circumstances.
counsel is here and
My lord.
the in counsel is outside.
My lord, under the certain urgent matter, in an urgent matter of the state, I had to come to Calcutta, my lord, for attending a matter in the Calcutta High Court. Am I audible, my lord? Am I audible, my lord? Is your case?
Actually, our case is that they have not obtained this certificate.
Okay, whether
Can appeal.
Lots.
In an application filed by the respondent herein for early hearing of the second appeal on the ground that
Citizen and
the execution proceedings have been stayed. Taking into account that the said appeal is of the year 2016, this court is of the opinion and the litigation dates back, is pending for the last 26 years. It is the opinion of this court, this is that reasonable ground has been made for the purpose of fixing the matter for early hearing, fixing the accompanying appeal for early hearing. Accordingly, this court fixes the matter, the accompanying second appeal being RSC number 23223 of 2016 on 6th of August 2024 for final disposal. The liberty is given to the parties, to the councils to mention the matter for upgrading. I stand disposed. Yes, Mr. Banerjee. Yes, Mr. Mazumdar.
yes, madam. This is an appeal against an order dated 3/8/2023 passed by the learned Chief Judicial Civil Judge Jorhat in MISJ case numbers 21 of 2000, rejecting the appellant's petition under Order 39 Rule 4 for setting aside an ex parte ad interim injunction order dated 3/8/2012, which your lordship will find at page 159. Whereby the parties were directed to maintain status quo. And the matter relates to the suit filed by the respondent herein in respect of equity share lying in the defendant number 3, that is the respondent HDFC Bank. Now the suit was for a declaration that the plaintiff, although the shares stand in the name of the plaintiff as well as defendant number 2, the declaration sought that the shares, the plaintiff is the sole owner of the shares maintained in the demat account of respondent number 2 bank in the name of defendant number 3.
Who is the appellant?
Appellant is the defendant number 2.
Defendant number 2.
Yes,
He is
I'm
the
the defendant number
defendant.
2. Yes,
Okay.
ma'am, defendant number 2.
Then
Now
what-
shares are standing in the name of the plaintiff as well as defendant number 2 admittedly. Now the plaintiff filed the suit for a declaration that he is the sole owner of the shares.
The entire shares.
All the shares lying in the demat account of HDFC Bank and maintained by defendant number 3, who is the respondent, contesting respondent herein. Now, what happened on 13/8/2012, an ex parte order of maintaining status quo order was passed. If your lordship goes to the prayer made in the injunction petition, lordship will-
Wait.
Madam.
13/3.
13/8/2012.
2012.
Yes.
Order of?
Order of status quo. My lord, the order of status quo was passed in an on an injunction petition, wherein if your lordship goes to
There is
kindly
an
goes
order.
and my lord, order before I take your lordship to the order, my lord may kindly have a look.
2012, yes, page
My lord.
49.
My lord,
What is
page
the order?
49 is the order. Yes.
The fact it appears that the parties are disputing the so and so, so it would be just an area, granted area without hearing the other. However, keeping in view the attending facts in respect to the aim of the matter. Truth. That is, equity says lying area till the hearing of the injunction would meet the ends of justice. So this is the order.
My lord. So, my lord, my submission before lordship is, my lord, this order was passed on an injunction petition filed, where your lordship will find the prayer is the made apprehending that I may dispose of the shares, I may sell the shares. So, basic prayer that they made is that I should not sell the shares. Now, taking advantage of this share, my lord, although I have got a stake of 27%, I have not been allowed to enjoy the benefit of the shares because the respondent hearing, Mr. Banerjee, Chatterjee, Somnath Chatterjee, he is running the whole show and I am out. For that, my lord, I have filed this application for
Where
modification.
is
Now,
the
the
injunction application?
injunction application, your lordship will find at page
Any
32, my
transfer
lord.
in whatever
32.
nature in the respect of so and so with the opposite party number in mind in hearing and further restrain the opposite thing, the delivery slips lying with the opposite party number.
From causing any transfer in whatever nature in respect of so and so shares of BA Limited lying with opposite party number 3 in the account bearing number so and client ID number so and further restrain opposite party number 2 from using the delivery slips lying with the opposite party number 2 bearing number so and restraining directing the opposite party number 3, namely HDFC Bank Limited, not to transfer the so and so shares of BNA Limited lying in account bearing number so and
what
client
is
ID
this
number
using of delivery slips? What do you mean by this? Use from using the delivery slips. What is that?
Well, there I'm slightly this I'll have to take instruction. I am also this technical term I am also not very much aware.
This is the most
But
important. You are making the submission to the effect. Anyway, then what happened?
then, my lord, now when I filed the application, what is coming in the way is, my lord, earlier, my lord, when plaintiff died on 31/7/2013 during the pendency of the suit and when the ex parte injunction order was in
2013, plaintiff died.
Died. Thereafter, my lord, one Somnath Chatterjee, who is the party here, my lord, respondent, he filed an application for substituting his name in place of the plaintiff.
Why?
By Somnath Chatterjee, my lord.
Why?
He filed the application on the ground that there is a so there is a will executed by the plaintiff, making him the beneficiary. And
Making
the will
him
was
the
dated
beneficiary,
my lord.
Okay.
Now, on 23rd of December 2013, the trial court considered the application for substitution, and after hearing the parties, since the will is not probated, the trial court has passed an order that the probate petition will remain in abeyance as well as the suit. That was an order passed on 23rd of December 2013. Thereafter, my lord, being aggrieved, 23rd of December 2013.
Then what happened?
Then, my lord, this order was put to challenge by both the parties before this honorable court in CRP number 47 of 14 and 97 of 14. But both these petitions were dismissed on 14/11/2014.
Why?
My lord, that order, my lord, possibly is here. I'll just show, my lord. And thereafter, no appeal was taken to the Honorable Supreme Court. Meanwhile, my lord, in 2020, an application for abatement also was filed before the trial court, which was rejected and no revision was preferred as against that.
Huh? What was filed?
Application for an abatement, praying for a direction that the suit has abated because plaintiff has died and there has been no substitution.
Then
Then
there's no substitution application filed.
Application was just now stated, my lord, substitution application was filed by Somnath Chatterjee. That is kept in abeyance by an order by the trial court on 23rd of December 2013.
Okay.
As
Then what-
against that,
No.
because by the state order, the substitution petition as well as the suit were kept in abeyance. Against that, 2 revision petitions were filed by both the parties. My lord. I also filed as well as the Somnath Chatterjee. Now, these 2 revision petitions were numbered as 47 of 14 and 97 of 2014. And both these petitions were dismissed by order dated 14/11/2014 by the Honorable Court. Then on 7th of March 2020, I have filed this application for a modification of the order because I have not been able to enjoy the fruits of the shares which I am holding, which are lying in my name. And that application has been rejected by an order dated, my lord, 7th of March 2020, which you will also find as page 127. I'm sorry, my lord, the application was filed on 7th of March 2020. It was rejected on 3rd of August 2023. Our application is at page 127.
Now, what has happened to the probate proceeding?
My lord, they are not taking any steps for last 10 years. It has remained pending. And that is the reason we had to file this application, my lord. Absolutely no steps have been taken for disposal of the probate petition. This is a specific plea we have taken in the application as well as in the present appeal, my lord.
Yes.
Some very serious factual corrections, my lord, will be required. My lord, first of all, my lord, I'm sorry, my lord, learned friend, my lord, has not been, my lord, able to give, my lord, at least, my lord, the correct picture, my lord, with regard to the facts. My lord, the original plaintiff, my lord, acquired, my lord, about 9 lakh shares, my lord, in this company. It was in his name. The present petitioner, who is the defendant number 2, my lord, in the suit, is the daughter of the plaintiff. The shares for operational reasons was also put in both their names, my lord, in the dematerialized account. My lord asked, my lord, what is delivery slips? Delivery slips, my lord, are like checkbook. You sign them, and my lord, then my lord, the shares can be transferred from dematerialized account to some other account. During his lifetime, the plaintiff, my lord, wanted to transfer the shares to, my lord, a family trust which he has created for benefit of all family members. My lord, the plaintiff had, my lord, this daughter, one elder daughter, and a predeceased son's widow, and my lord, their children. This is, my lord, the family of, my lord, the plaintiff when, my lord, he was, my lord, alive. He requested or asked his daughter to sign the delivery slip so that, my lord, the shares can go to the family trust. And my lord knows in India, my lord, there is no theory of advancement, which means if the shares are bought by me, it stays in me. Unless the other side can prove that it was really meant for both, because it was acquired, my lord, by him. And my lord, when she refused to do that, he during his lifetime filed a suit asking for her to sign the delivery slips as well as a declaration that you have no right with regard to the shares. This was, my lord, filed, my lord, in 2012. The interim order, my lord, was also passed in that suit, 13th August 2012, and my lord, that has been continuing. I'll tell my lord why it's been continuing also. And my lord, also very important, the defendant number 2 has never exercised any right with respect to the shares. Never, no voting right, nothing. Because anyway, she was the second name, my lord, in the dematerials account. Then, my lord, unfortunately, plaintiff passed away, my lord, in July 2013. He left a will of 17 September 2012. In the will, categorically, the shares have been directed to go to the family trust. He has also disinherited and disowned the defendant number 2. It's a registered will. my lord, probate proceedings have been filed in Calcutta. In the Calcutta High Court before the Calcutta it's pending. My learned friend said, my lord, we are not taking steps. A very unfortunate, my lord. I'm sorry, I'm sure, my lord, he's not been, my lord, instructed on that. We have also annexed orders. The only person who's opposing grant of probate is defendant number 2. The other daughter has given her consent. The predeceased son's wife has given consent. So she is the only one who's opposing. And my lord, we have annexed orders, my lord, at pages 350. I'll show those orders. Where my lord now, not only opposing, but also made application for amendment of my lord, the written statement and taking time there. I'll show my lord, those orders are there. Now, my lord, when we made an application for my lord, the purpose of substitution, because my lord, the executive my lord, knows under section 211, 212, 213 of my lord, the Succession Act, the executive my lord, has made us application for substitution to be my lord, as executive to my lord, to substitute for the plaintiff. The district judge, my lord, the district judge held, that's an order of my lord, 23rd December 2013, held that until the probate application is decided, everything is kept in abeyance. The suit, my substitution application, everything kept in abeyance. My lord, I preferred a civil revision petition. My learned friend's client also preferred a civil revision petition before this honorable court. That order, my lord, was affirmed.
Mr. Manager, don't you think that the order is wrong on the face of it in view of the definition of what is legal representatives?
My lord, my lord, fully agree with what has fallen, and my lord, we argued also on that. In fact, my lord, if my lord sees the arguments, I argued, no, you have to allow substitution. My lord, the learned district judge, my lord, relied on, my lord, a judgment, my lord, Nirmas Bina Pani, my lord, of the Supreme Court, where there's one stray line saying that because it says you can't pass the final decree, otherwise substitution will happen. That's one of the law as I, my lord, understood.
Yes.
The word is anybody who intermeddles with the estate of the deceased would also be.
Absolutely. My lord, anyway, my lord, we got stuck with that order. My lord, 2014, my lord, we got stuck with that order. My lord, we tried to expedite the probate application. It's been opposed, my lord, by them, which is, my lord, still pending. Now, 2014 onwards, my lord, they're also lying quiet. In 2020, 2 applications are filed. One, my lord, is miscellaneous 21 of 2020, which is this application, saying, my lord, it's under Order 39, Rule 4, for vacating of, my lord, the earlier order. There's also an earlier Order 39, Rule 4, which is also pending. And, my lord, miscellaneous 22 of 2020, for the purpose saying that there's no substitution, therefore it is awaited. Show cause notices, my lord, were issued on both, and the file on the both day, same day. My lord, notice, my lord, was issued on 7 March 2020 on, my lord, both the applications. Now, what they did, because I'll show, my lord, why this appeal is an abuse as well. They preferred a revision from that other application, miscellaneous case number 22 of 2020, before this honorable court. My lord, that revisional application, my lord, was dismissed by an order, my lord, of 26th July 2021 with observation saying that, my lord, it is a, I'll just, my lord, show, my lord, where the observation is. Yes, I'm constrained to hold that the petition miscellaneous 22 of 2020 filed by the petitioner is a misleading one by this court. They went up to the Honorable Supreme Court. Supreme Court also, my lord, dismissed the special petition. And there also, my lord, we have got the grounds. They tried to have this order vacated. So it's not my fault that, my lord, this application can't be heard. So there also there are grounds to the effect saying, my lord, that the order should be vacated, which is, my lord, here. Then, my lord, they started the next round. Is, my lord, going ahead with, my lord, this miscellaneous application 21 of 2020. And it's not been, my lord, dismissed. It's been kept in abeyance. The impugned order keeps that also in abeyance. And, my lord, kindly note, my lord, the order, my lord, what is the language? I don't know why, how, my lord, the learned judge, my lord, has made a mistake, because the learned judge only says in keeping it proprietary with what has already transpired. Kindly see, my lord, 159, my lord, is the order, impugned order.
That is understood, but how do you take care of the situation? Yes, there was a mistake. I am saying that the order which was passed by the division, by the courted bench was.
My lord, we got, my lord, I absolutely, my lord, correct.
Because what I understand from the basic idea is why the legislature has put it 90 days and otherwise abatement, so that the suit can proceed.
Yes.
We see the judgment of Amarjit Singh also 1975 also says that the suit has to proceed. That is the basic idea.
My lord, Bina Pani 92 Supreme Court is a three judges bench. And there's only one line there, my lord, which said that the suit also should not be proceeded with. And my lord, I argued that please allow the substitution application. That's why, my lord, I also prepared a revision petition. But my lord, we got stuck, my lord, with that order of 2040. And I'll just kindly look at, my lord, this impugned order at page 162.
Yes, just before me.
My lord has already seen that, my lord.
No, it's okay, but how to take care of the situation?
My lord, they should, my lord, really, my lord, not oppose the actual, my lord, kindly see, my lord, page.
That the not opposing would be it would be a
No,
death
he, my
knell
lord,
to
my learned friend can't.
no, not opposing the probate would be a death knell to the instant proceedings. Because the probate categorically says, as you said, that the plaintiff, the erstwhile plaintiff had already inherited her with these shares and put these shares in the name of the family
My lord,
trust.
this she's claiming, my lord, because she says she's a named
No, whatever
second
may be.
named shareholder in that.
No, that's true, whatever
Correct,
may
correct,
be.
correct.
But if she allows the probate to happen, the matter
Well,
becomes.
They are stuck with that situation. They have never exercised any right, my lord, with regard to the shares. They cannot. Because even under the articles of association of the company, which was also challenged, my lord, in a company proceeding, there also, my lord, the articles say the executor has the right. It's not automatic. The first named person, if he dies, if it's joint holding, then, my lord, the executor has the right. So I'll have to have my suit tried out. And from 2014 till 2020, and kindly see, my lord, how they do, my lord, two parallel proceedings filed immediately.
No,
What?
I'm not concerned with this, but something has to be done because you see, keeping a matter suit pending out there for all this while doesn't happen. Yes, he may not be entitled to do this. I'm more concerned with that. Can you file an application under 151 before this court for recalling of this order? Taking it as a mistake of the court, taking into account that order 22, more particularly the constitution bench judgment, review not possible, it is too long a day, but on recall.
My lord, unfortunately, my lord, 2014, where both our civil divisions got dismissed, we both have accepted the order. And from 2014 till 2020, my lord, we sat quiet. All of us.
But if it is a mistake of the court,
Both of us
because if you
sat quiet.
see basic idea. That is why, otherwise, why would the legislature just put it in 319 that they could have very well put out there that anybody, the legal representative shall be the person who succeeds to the estate of the heir. That can be very well. But why did it also put one who also intermeddles with to the estate of the estate of the deceased? The word intermeddling with the estate of the deceased means a person who is also
Yes,
doing something.
but
to
here, my lord,
fulfill.
no question of intermeddling. Because, my lord, the situation is plaintiff is one of the shareholder. He was the first named. It's plaintiff shares. Plaintiff filed the suit saying that you better sign the delivery.
No. I'm not saying about the plaintiff. I'm saying about you.
I'm the executor.
Being the intermediary
Yes.
with the estate of the deceased. That is what I'm saying.
Yeah, absolutely.
I think that
I'm not the beneficiary.
understood.
Yes.
But you are still, you have the right of intermediating in view of the provisions of 211 and all.
No, my lord, here also, so far as the suit is concerned, in the Calcutta High Court, order has been passed saying the dividend should be deposited, my lord, in a separate account by the executor, which is being done.
I'm not on that.
My lord is on the
can
general proposition of
Can you keep the suit pending like this? Because that cannot be the idea behind. That is why you have 90 days, then the abatement.
no, I have not kept the suit pending.
No, understood.
In
No,
fact, my lord, I applied
because
for
of this
substitution
order.
immediately. Yes.
Because of this order which has
Correct,
been
correct,
passed,
correct,
can you
correct.
keep the suit pending? They did not look into the second aspect of the definition of legal representative. The
Well, that
definition of legal
Orders
representative.
there, if my lord wants to have a look at the order.
I've seen the order just now.
No, my lord, the original order, my lord, where, my lord, our revision petition, my lord, where both, my lord has seen that. 2014.
Justice Indra's judgment.
Yes.
I've just seen.
Sorry, my lord, I didn't realize, my lord, is already, my lord.
No, it is there. on
Gone
the
through
court.
that,
I
but-
was, in fact, when you were submitting, I was just looking into that. Because only thing is, worrying is, that is absolutely contrary to the idea of Order 22. You see the judgment of the Supreme Court, the Constitution in Amarjit's 1975, categorically says why Order 22 is there. Not for the purpose of derailing or doing anything, it is only for the progress of the suit.
Yes.
The suit can progress. Now, if you see the legal representative meaning also, that maybe these are the people who would be normally, there's no problem. But the moment there is a problem out there, anybody who intermeddles with the estate of the deceased can also be brought in as a legal representative.
Yes.
So under such there's such a wide or expensive definition being given to the provisions of Order Section 319 as well as by to Order 22. Wouldn't it be too constricted the view which is being taken by this court? Because you can't keep a suit pending like this on the basis that this is going to happen. I understand a suit kept pending for the purpose that what will happen out there is regards the probate. Yes, a suit can be kept pending for that. That would be an in exercise under 151. It can be done. But
to keep my
on
substitution
the basis
application
of
also
this,
pending.
nothing is going to happen.
Substitution application also get pending.
Yes, you can't
Because
keep
substitution
that.
application also kept in abeyance. But naturally, the suit is kept in abeyance.
My lord, if your lordship permits me for a moment, my lord, in this case, actually the substitution should have been granted. Only the final decree cannot be passed unless the will is probate is produced in the court.
Understood.
That is the law, my lord.
No, that I know. But the only question is,
My lord.
you see, the basic idea behind staying or keeping the suit in abeyance on the ground of substitution, you can't keep it. That is not called for. That is not envisaged by the legislature at all. That is what I am saying.
My lord, my lord.
It is never thought of. That is why will the legislature otherwise put 90 days or automatic abatement?
My lord, this is what my lord, I argued, and I was very disappointed that my lord, I was unsuccessful. But somehow, my lord, no one my lord, pursued it further.
Somehow, both of us kept quiet, my lord. Today we have got up, my lord. Both of us kept quiet after the order was passed by Honorable Justice Indra Shah. My lord, one submission I have to make. My learned friend has made certain submissions on merit. I have to clarify. My learned friend says my client's name is as a second name. My lord, there is no difference between first name and second name. If my name is there, and if you think that you are the owner of the shares, why did you file the suit then? You are aware that if my name is there, I am also owner of the share, unless the court passes a decree. This is one. Secondly, my lord, my learned friend is making a submission that in the probate proceeding pending before the Honorable Calcutta High Court, I am resisting. I have a right to resist. Why do you presume that if the probate proceeding is allowed to proceed, you will get the probate? If the probate petition may be dismissed also. Why do you say that I am resisting as if had there been no resistance from my side, the probate would have been granted? That is not the correct position, my lord.
No, I'm not saying
I have a right to oppose. More so when by a will, if the entire property is given, Honorable Supreme Court has said that there will be a suspicion, presumed suspicion, and you will have to clear the suspicion. Unless you clear the suspicion, you will not get the probate. That is the law, my lord.
No, Mr. Ravindra, I am not into all this.
I know, my lord. I know, my lord. My lord, this aspect of the matter has got no bearing.
Come back to me.
My lord, this aspect of the matter.
What to be done with this order?
My lord, may I just?
I know, my lord. This submission which I have made in response to my learned friend's argument doesn't have any direct bearing on the merit of the present case. But I have made the submission because my learned friend.
No, we will consider that because only which, in respect to the entire proceedings, is
my
that
lord,
being stated.
Absolutely, man. Absolutely.
Done. Whatever you do, that is your lookout. But how can you stay keeping abeyance by keeping the
my lord, one way, my lord, at this stage, one way out, which I see, my lord, subject to correction, my lord, that both the parties file an application for review of the order passed by Honorable Justice Indra Shah.
Yes, better. Not review, recall.
Review, whatever, my lord.
Because
I think both the parties should come forward and file an application.
Review the limitation will hit you, not the recall.
My lord, recall.
Submission, my lord, in the probate, my lord, they should not, my lord, take any unnecessary adjournment. My lord, let us also, my lord, agree on that.
That is another aspect. But
because, my lord, that is also, my lord, we want to have the probate.
Whatever may happen out there, that is a different thing. But something has to be done with this order. That then you see, it is something like a block being put into the into a free flowing river.
And unfortunately, my lord, it has survived right up to the Honorable Supreme Court as well. That's the problem. Because my lord, last round when they filed, the same thing happened. Kindly look at that
Yes,
order.
indirectly, my lord, the
court.
order passed by Honorable Justice Shah has been.
Page 221,
Yes,
kindly
yes.
look at that order. Page 221 of the of the reply.
Yes, the SLP dismissed.
And just before, kindly look at the order as well, my lord, which is at page 213. And kindly see, my lord, page 219. Paragraph 15, page 219, paragraph 15. This court has already agreed that till the probate is granted to Mr. Chatterjee, TS should be kept in abeyance. Therefore, this court is of the opinion that the act of filing the petition before the learned court below seeking an order that the TS number 41 stood abated is contrary to the spirit of the order passed by this court in CRP number 47 2014 and CRP number 97 2014, constrained to hold that the miscellaneous petition filed with misleading one.
That is a different aspect.
Yes. My lord, just one more submission, my lord, if your lordship kindly permits me. That is also a reply to my learned friend's argument, which may not have any direct bearing on the today's appeal, my lord. My learned friend has made a submission that in the will, I have been sought to be disowned and I have been sought to be disinherited. My lord, under the Indian law, there is no concept of disowning or disinheriting because for extinguishing.
Mr. Majumdar, let me get transferred to Calcutta first.
Please, my lord is more than welcome, my lord. If not, it helps.
Before that, let us not go into
This
that.
honorable court would object tremendously, my lord, if we take away.
For that, it is okay. Not for me to look into.
My lord,
Let's keep this matter some other date on which
My
they
lord.
will come up and do something as regards that order. Something has to be done. Once
My
we do that, then whatever happens, because I am 100% sure that is the law which stipulates that Order 22 is not a provision by which you can stranglehold the proceedings. It is
My lord.
only for the purpose of a free flow of proceedings.
Free flow, exactly,
Both
exactly.
we failed. Well, the two civil revision petitions, my lord, I argued before
No,
the
understood.
district judge.
But what to do? What to do? You can't keep this matter pending. This is absolutely against the legislative intent. It is absolutely against the constitution bench judgment.
I also want my substitution application to be, my lord, allowed so that, my lord, I can
Yes,
proceed with the
because
suit.
I think you can be very well, you can be substituted. Yes, a judgment cannot be passed.
Yes,
Till
yes,
the
my lord.
probate is not
Yes.
given.
Yes.
That is the law. But you can very well be done.
Absolutely, my lord.
So the keeping
My
out
lord,
there will not be in
my
the
lord,
interest of the-
Madam, I think, my lord, the only option open today is to file an application for recall of the order passed by Honorable Justice Shah, my lord.
Yes,
I do not,
file something.
my lord.
Let us take
Maybe,
up the matter on some other day.
maybe, my lord, yes.
Once that is there, thereafter everything will go. Everybody will
Absolutely,
decide what else to do.
absolutely, my lord. Yes,
That is
yes.
the only way out. Whether you are entitled or not, I'm not concerned to that effect. Here also,
My-
Mr. Muzumdar, you have to see out here. You
My
file an
lord.
application for vacating of an order of so and so.
My lord.
Now,
My lord,
that
here,
application the court has actually
my lord.
not decided this way or that way. The court has kept it in abeyance.
My lord, primarily,
Therefore-
your lordship may kindly give me
Something
1
has
minute
to be
here.
done.
My lord, lordship will kindly give me 1 minute here. My lord, in fact, the learned trial court has primarily relied on the order passed earlier that the matter is kept in abeyance. Well, here I have got one submission. I have 2-3 judgments to show that in a case of this nature, for clarification of an order passed at an interim stage, even if there is an order of stay of further proceedings of the suit, it can be passed.
Mr. Mazumdar, you are referring to the 98 judgment. That is
My lord,
there is a
Indian
case
Bank,
where
Indian Bank.
Section 10
10
application was
That's
filed.
right.
Where the
True,
Supreme
true,
Court
man.
said when a 10 application, then also the injunction proceedings.
Yes,
But
yes,
here
yes,
is
my lord.
not that, not 10. Here it has
Well, there
been
is-
said on the basis that there is no, as if today, if you don't substitute, you
My
cannot
lord,
pass
proceed with
any
the suit.
order, even vacate that order. You can't vacate that order against the dead person unless the dead person is substituted. So that is the analogy, or those judgments can't apply.
Absolutely.
Only way is how to just remove that obstacle. Come up with a final, yeah, we have it after vacations.
My lord, may I then request, my lord,
My
the
lord.
end of July, my lord, 30th or 31st July, my lord, 31st July.
But 30th and 31st, I've got some difficult. Lost may keep on any date in the
August.
first week of August. First week of
First
August,
August.
man. First week. First or second.
You have a difficulty on 30 and 31st. And first week of August is also on 1 and 2, that is of the same week. Then how to do?
Well, 1 and 2 Lordship can, or any date thereafter, my lord. Subject to your Lordship's convenience, my lord.
Yes, anything on the first, we can have.
Yes.
My lord, my lord.
This the matter which upon hearing the learned councils of the parties, this court finds it relevant to observe that a further hearing would be required in the instant matter. Accordingly, the matter be listed again on 1st of August 2000.
I'm very grateful, my lord, so there's a pleasure.
I'm deeply obliged. Deeply
Kindly
obliged.
come up with some solution to this.
Solution,
Only
absolutely.
that if we can remove this, then it's okay. Thereafter,
My
whatever happens, it happens out there.
Absolutely, my lord.
Many things can happen out there. The suit
Because
can
in merits
proceed
also,
out.
my lord, I have lots to say, but my lord, that also has not been considered. Because my lord has been kept in abeyance in
fact,
view of
it
my
is
lord.
also inconvenience to you also.
Yes.
Because your suit is not proceeding.
Yes.
At the end of the day, whatever may be, the probate has happened out there, but the probate has happened. What will happen if the probate is granted?
As immediately the suit will proceed.
No. Forget about this. Whether the
On merit,
subject matter of the suit would already would be over.
No, probate doesn't decide my lord title too.
my lord, probate doesn't decide any title. So suit
law
has
is-
to be decided on its own merit, my lord.
So probate is my lord only my lord for me to go and my lord say that this is the will. It's a registered will, my lord, to show that this is a genuine will, my lord, and go ahead with it. I have consent, my lord, of all the other heirs. She's the only one, my lord, who's my lord. And what they have now
Lordship-
done, filed an amendment application there saying that you take out the shares from the will. I'm sorry, my lord, I don't know how that application went, we are contesting it. They
My lord,
also
let us
taking
not
time for
argue, my
filing
lord.
affidavit.
Let my learned friend not argue on the merit of the probate here.
Would only mean that this is your property.
That my lord, the
and you
will
have
is genuine.
given it to so and so, bequeathed this property
Yes.
to so and so.
Yes,
all.
yes, that's all.
Correct.
But the fact as to whether you are the owner of the property or not,
It will not be decided.
That
It will
the
not be
suit has-
decided. Suit
That
has
the
to
suit has to
decide.
decide.
Yes, ma'am.
The will says, my lord, it is in his name. The will says where it will go.
provided it is.
Provided, my lord, yes.
Yes. That is the law, my lord.
Okay, we'll
Deeply obliged.
My lord,
Deeply
my
obliged.
request to my learned friend, my lord, is to at least, my lord, in Calcutta, not to, my lord, go on, my lord, taking adjournment there.
My lord, about the
My lord, if my
Calcutta
learned
proceeding,
friend, my
let
lord, is a serious, my lord, if he insists, my lord, I'm
about
sure, my
the-
lord, if he sends
my lord, let me
instructions,
say
don't
on
do
the-
take
about the-
unnecessary adjournment, my lord, we can have
my
that
lord,
over. We are
my-
ready. My lord, we have filed our
my lord,
judges
about,
leave, everything.
my lord, about the,
Application has come for amendment of asset assets.
my lord, about the proceeding in Calcutta in the probate petition, my lord, I have got absolutely no idea, my lord. I have got no instruction. Let my friend not argue on that, my lord, except for the fact that matter is still pending.
It's the same party, that's why I'm not bringing that attention. Because we have annexed the orders as well, my lord, in this procedure.
True.
You can ask
Now I'll try to
Yes.
find out who has done what in the
him.
probate
He is
proceeding.
newly into the seat.
Yes, my lord, we'll do that. I'm so grateful, my lord.
Deeply obliged.
Nine matter.
Prashant will the case due to some personal difficulties in.
My lord, in that event, my lord, I pray let the matter come up after vacation, my lord. I have got some personal difficulties next week, my lord.
Yes, argue.
Mr. Chiu Loskar will do the case.
Who?
Chiu Loskar.
So what? We have taken adjournments on 3 occasions. No grounds. Nothing doing.
Tomorrow,
Absolutely no. Kindly see the orders which have been passed. 22(5)(a), taking into account the survey, list the matter for hearing in the usual course. Matter comes up on 11/6/2024. A prayer for adjournment has been made by Sri Tuya Lasse, who submitted that he has been instructed to appear on behalf of the appellant in both the considering these appeals are of the year to that. While the prayer for adjournment is declined, a small accommodation is granted till 13/6. Accordingly, list the matter on 13/6 under the column top of the list. Both these appeals arise on next on 13/6. The TU law score for the AS is present. However, a prayer is being made on behalf of AR who appeared on behalf of the ORIA. Considering the appeal is of the AR, short accommodation is granted, directing listing of the matter on 26. Then,
some personal
so what?
differences.
Nothing doing. Argue.
Tomorrow,
No. No tomorrow business.
I am not aware of this case, Lord.
Can't help it. Not aware of the matter. Yes, Mr. Bhattacharjee, why there are 2 appeals?
Well, basically, it's a concurrent findings by both the court, my lord. But the issue is whether the sale deed by virtue of which they sought to establish their right, title and interest, my lord. That was rejected by both the courts below entirely on the grounds that that was the certified copy and they failed to produce the original.
Sale deed.
Sale deed, correct, correct. That's the sole ground, my lord. Other grounds, my lord,
Plaintiff,
they were the plaintiffs.
they produced the certified copy.
Certified copy of the sale deed on the basis of which they sought to establish their right, title and interest, my lord.
And that was rejected.
That was rejected entirely on the ground that it is the certified copy not admissible until and unless they produce the original, and they failed to produce the original.
And in the appeal,
In appeal, the same finding was upheld.
they did not take any attempt for producing the under order 41 rule.
No, my
47.
lord, no, my lord. The judgment does not reflect anything, my lord.
And you filed a counterclaim.
I filed the counterclaim that also came to be rejected.
What was your counterclaim?
My counterclaim, my lord, I based on earlier title suit, my lord, and pleaded that the current suit is barred by res judicata, my lord. That was rejected by the trial court, but the appellate court held that the suit was barred by res judicata.
Why there are 2 appeals? You filed against the counterclaim. You filed an
No, my
appeal.
lord, I am appearing in item number 21, my lord. RSA number 53 of 2009, my lord. I don't have any notice or something regarding item number 20, my lord. That is RSA number 54. I was not served with any notice. I got notice in only RSA number 53 of 2009.
So your counterclaim was decreed by the first appellate court.
Yes, my lord.
So your counterclaim is allowed.
Yes, yes, yes. My counterclaim was allowed.
So this appeal is against the counterclaim.
So 53,
54 is against the counterclaim.
my lord, in which I did not get any notice. 53, I am appearing in RSA number 53, my lord. In 54, my lord. In 54, I am not appearing.
In 54, in that no substantial question of law has also been framed. what they have done, there is in one appeal, 53, you see there are three substantial questions of law.
Correct, correct.
The third substantial question of law is actually
Related to
against that
54.
54.
Related to 54, my lord.
54. And as such, there is no framing of any substantial question of law there.
Perhaps. That is why we did not get any notice of,
See, these substantial questions of law, however, in my opinion, does not become a substantial question of law in view of the fact that the learned First Appellate Court categorically held, came to a finding that the sale deeds which were executed were much later than the decree which was passed
correct, correct,
in 1996.
correct.
And as such, it did not hold any water.
Correct, absolutely correct.
So this is the finding of fact.
That is the finding.
Once that is the finding of fact, there is no substantial question of law framed on the basis thereof. So
Absolutely.
without that, can it be say that it will change the course of the litigation without that being a substantial question of formulated?
Because substantial question number one, my lord, whether the certified copy of the sale, my lord, in 53, what has been framed, whether the certified copy is of the sale deed, they sought to prove.
That is kept as secondary. You see the decision in the other appeal, has been done in your favor, the counterclaim being allowed.
Correct.
If you see the judgment out there, it categorically says one thing. An example, paragraph number 5 of that judgment. It surfaced that Exhibit Go is the order of the learned Assistant District Judge Hailakandi dated 19/2/1996 in title suit number 62 of the 9, that the suit plan as mentioned in the schedule of the plaintiff have already been decreed in favor of the appellant.
Correct.
Besides, the respondent could not produce or prove any document showing that the aforesaid decree was set aside and also could not show how he became the owner of the suit land by showing the quantum of land that the co-sharer had obtained from the decreed land of so-and-so. Further, it appears that the suit was described in the scheduled land is included in the suit land as described in the schedule of title suit number so-and-so. In this context, the respondent could not show how from the decreed land he had been able to purchase the land from one Krishna Orang by submitting an authenticated and substantive document.
Correct.
Therefore, the sale deed dated bearing number dated so-and-so does not seem to hold water as the respondent could not produce any authenticated copy regarding the sequence of events.
Correct.
That is how a portion of a suit land as mentioned in the schedule to the plaintiff was sold out to him, which was a part of the decreed land as mentioned in the schedule to so-and-so. Moreover, the decree in so-and-so was passed on the basis of Exhibit 4, which seems to be an authentic document. Besides, Exhibit 4 seems to be a valid document, and on the basis of the said document and other relay, it seems that the decree was passed on title suit number so-and-so, authenticating the right title and interest and possession of the suit in favor of the appellant as the decreed land which is included in the suit land as mentioned in the schedule of so-and-so. In view of the foregoing analysis of the evidence on record, it appears that the sale deed so-and-so is void and inoperative.
Correct.
Now, with this finding being there and that not becoming a substantial question of law, can they have any right over that?
In my respectful submission, no, your lordship.
So, and then nothing remains out here.
Yes.
So, finished. 2009 matter finishes.
All right, Chief.
What? No, first of all, your senior has taken this court for granted. And he should know that some court may be or may accept to your adjournment request. And this court is very particular not to grant such things. And if I grant you an adjournment today, everybody will ask,
supposed to argue the case or
Huh?
here's the case. I am
So we'll put it non-appears, so we dismiss both the appeals. Then, first of all, how did you appear you without a file? You have the file.
I have the file
Oh, fantastic. Again,
and name is also not shown.
not necessary. You know the matter is there in the list.
One day, my lordship.
Mr. Bhattacharya, I'll put it up next Tuesday.
Next Tuesday.
No, I've heard you. I heard you. That thing on Tuesday, formally dismiss it in presence of his senior.
Let it be on the top of the list in that event.
Yeah, yeah. Will be on the top of the list.
And
As soon as parted.
Yeah.
The top of the list. So this both the appeals are directed against both the appeals arise out of a common suit being title suit number 24/2006, wherein a counterclaim was filed by the respondents herein. Respondent or respondents?
Yes, actually, what happened, my lord, the respondent and our sole respondent died, my lord. They got substituted. Actually, I am appearing for the respondents on instruction, though I could not file the Wakalatnama. Wakalatnama is in transit, my
Okay, okay, no problem. Now respondent.
Yes, now respondents.
I'll better respond. Wiki लिख ले तू. Respondent, the predecessor of the present respondents. The trial court, by judgment and decree dated 25/6/2007, dismissed both the suit as well as the counterclaim. Against the said dismissal, by judgment and decree dated 25/6/2007, 2 appeals were filed. One appeal was filed by the plaintiffs, which was registered and numbered as title appeal number 19/2007. And the other appeal was filed by the respondents,
Title appeal number 20 of
which was
2007.
registered and numbered as title appeal number 20/07. The first appellate court, by its judgment, by 2 separate judgments, by the judgment and decree dated 29/5/2008, dismissed title appeal number 19/07, and being agreed, RSA number 53/2009 have been filed. The learned first appellate court, however, allowed title appeal number 20/07, thereby allowing the counterclaim. By the judgment and decree dated 29/5/2008. And it is against that RSA number 54/2009 was filed. This court, taking into account that in both the appeals arises of the common set of facts had formulated three substantial questions of law by an order dated 3/6/2009. A perusal of those substantial questions of law so formulated shows that the said substantial question of law are interconnected with RSA number 53 of 2009 and RSA number 54 of 2009. The counsel for the appellant, upon placing the materials, submitted that she needs further time on account of addressing further arguments. In the meanwhile, this court had duly heard Mr. S. Bhattacharjee appearing on behalf of the respondents. Taking into account that the matter have been heard, matter be listed on 25/6/2024 at the top of the list, showing it as part heard. Madam, last chance, no more. So on 25, this is the final, this way or that way it is happening.
Obliged, Your Lordship.
Yes, any more matters? Anybody interested? Yes, where? Whole matter? Where they?
Lord, though it is a concurrent finding, my lord, filed for declaration of right title interest and for recovery of possession and confirmation of possession. So far with the right title declaration is concerned, my lord, they have claimed that schedule 2 land be recovered from me. But in the pleadings as well as on evidence, it is admitted that they have sold out the land to me, exactly the land which is in the schedule 2 land. So far with respect to recovery is concerned, my lord, they will have to prove that we have been dispossessed. And
Whether in view of the judgment passed by this court by the exhibit N, the learned courts below committed error in declaring title of the plaintiff over the suit land, which is exhibit N. Nothing more. Only one substantial question of law. Oh, record.
of them. But in the pleadings also it is admitted they have sold out the land.
Huh?
By exhibit N, they have sold out land to the plaintiff.
No. Whether in view of the judgment by this court, by the exhibit N, the learned courts below committed in declaring the
Title in favor of the plaintiff. In favor of the plaintiff,
What is exhibit N?
by which I have acquired title from plaintiff.
Then, now where is the some judgment was passed by this court? Then why is this substantial question of law formulated?
It is for the first time.
Exhibit N is the judgment in SA number, Lordship.
It is
Huh?
regarding
In SA number,
it is,
exhibit N is the judgment passed by this court in second appeal, Lordship.
Oh, it is with respect to second appeal. And
Where?
second appeal.
Exhibit
Judgment
N.
dated 22/8/89. High
And
Court's
the-
order in second appeal number 10, Lordship, of 1980.
Exhibit K,
That is a pink flag, Lordship.
L,
Exhibit N, Lordship.
N. Okay. Defendant is the appellant before this court against whom the suit it both the courts below the. Who is the defendant here?
In this present case,
Defendant is Ahmad. No, who is the
Ahmad.
defendant? Defendant is the appellant on Asaq Ali. Who is Asaq Ali? Let us see your facts. What is your facts?
page 28, file.
Huh?
Plain, file by the plaintiff.
28. Mahmoud Ali. Mahmoud Ali is the plaintiff.
Respondent. Yes.
Okay, he is the respondent in the earlier proceedings, second appeal. And he was also the plaintiff in the earliest proceedings.
In regard to
And he is, and these are 1, 2 are Samjid Ali and Saifun Ali, who are, how are they connected?
if that is in regard to separate fakta, Lordship, different land. It is reflected in trial court judgment, Lordship.
Then why is that question of law framed?
Lordship,
In the plain, they have stated that patta number 165 has been carved out from 160.
Trial court already discussed. This exhibit shows that the plaintiff's mother had dispute in respect to land in some other patta. These documents are nowhere related with the present suit.
From the plain itself, that actually there is no cause of action to filing this.
You are the defendant.
I am the defendant. There is no cause of action in filing this suit.
Okay, now
Because-
tell me what is the case about?
Case is that the plaintiff filed the suit for declaration of right title interest over Schedule 1 land
Okay,
and recovery of possession of Schedule 2 land and confirmation of possession of Schedule 3 land. 2 and 3 are part and parcel of Schedule 1 land. Now, in the pleadings also, they have categorically stated that Schedule 2 land is in possession of the plaintiff, son Chirag Ali, and the defendants herein. But Chirag Ali was not made party in this suit. Chirag Ali is the son of the plaintiff. And this
where?
at page 30, paragraph 7.
Schedule 2 is for confirmation, for recovery of Schedule 2 land. From, where is it mentioned?
Schedule 2 land,
Where they have mentioned?
2 land mentioned at page 33 within Schedule 1 land measuring 3 katha.
The defendant and the son of the plaintiff Sirag Ali occupy the land to the east of the Schedule 1 land and PWD road situated to the west of Schedule 1 land, and the defendant has no land access to the PWD road from his body situated in so and so.
East of the Schedule
Defendant,
1.
with the help of the relationship for making wrongful gain in the last part of January, disposes the plaintiff from Iman and measuring field described in Schedule 2. Where is it mentioned that the defendant is also in possession with Sirag Ali?
Para 7.
Para 7 is different. It does not say that.
That the defendant and the son of the plaintiff,
Ah,
Sirag Ali, occupying the land.
to the east of.
East of, yes.
It doesn't say, but here it says, in last part, defendant says making wrongful gains from the Iman disposes the plaintiff from so and so in spite of protest on so and so. Then it doesn't say.
It kindly see then next paragraph number 3. How I have acquired these 3 kathas of land.
I'm not concerned with that, but that is a wrong for submission which is you are
No,
making.
in the evidence also it is there, my lord. Evidence.
I'm not going to look into evidence.
PW's evidence.
Sorry, what is your now the substantial question of law?
My lord, now substantial question of law is whether there is any cause of action on the basis of the pleadings for declaring the suit of the plaintiff when the plaintiff have failed about their disposition. Not a single evidence was laid that I have been dispossessed. So plaintiff has been dispossessed by me because I have also
That
cited.
is the question. Didn't the trial court look into it?
No, both the
Let the-
court below
No, what did they say? Let us see the findings.
findings. Yes.
There will be an issue framed of the trial court.
Trial court at page
Trial court judgment is
regarding issue number whether page 20 kindly see.
how is
Paragraph issue number 5.
where is the trial court judge? Yes, issue number
5.
Whether the defendant had dispossessed the plaintiff from the Schedule 1 land. I've heard here and I will decide here. What is issue number 5?
Page 25. Whether the defendant has dispossessed the plaintiff from the Schedule 1 land. They sought for recovery of Schedule 2 land. The plaintiff in his plaint alleged that on the last part of the January, defendant dispossessed him from Schedule 2 land, and on obtaining Jamabandi, he came to know that this name has been deleted from Jamabandi. Defendant denied the claim of the plaintiff. Plaintiff in his evidence corroborated and supported the plaint. PW1 also corroborated the plaint about such dispossession. The evidence of both witnesses remained consistent and unrebutted. Defendant in his evidence of DW1 did not deny the claim of the plaintiff side. Plaintiff in
Page 25, issue number 5.
yes,
The plaintiff in his evidence corroborated and supported his plaint. PW2 also corroborated the plaintiff about such dispossession. The evidence of both the witnesses remains consistent and unrebutted. The defendant in evidence, the DWA did not deny the claim of the plaintiff side. The plaintiff in his evidence explained the reason for such dispossession, that there was no access to the PWD road from the here. Hence, from this reason, the defendant dispossessed. This evidence has not been denied by DNF from the evidence of ER. The only conclusion that case can be drawn is the defendant dispossessed the ER. Then what is wrong?
my lord, wrong is that kindly see the evidence part of the plaintiff number 1.
Not
Yeah,
necessarily. I am
yes.
not. The question is doesn't arise. Now, how does the first appellate court look into it?
And regarding my title also, my lord, it is not, it is an admitted position. There is a title. My
Plaintiff
title
stated that
also.
he has been in possession of Schedule 1 land, carrying so and so, and the plaintiff also stated that he got the entire Schedule 1 carrying so and so. The defendant admitted possession over a plot of land of and because plaintiff sold out his land measuring so and so described in schedule 1 of that to the defendant number 1 later. Defendant exhibited exhibit J as the sale deeds through which the plaintiff's mother sold out the land to the father of the plaintiff of the defendant. But on careful perusal of the document, it reveals that the said documents are not related to the suit land. Defendants failed to show that the suit lands lies in the land from which exhibit G and K were prepared and executed. The defendant made no efforts to prove that they had possession over the suit land. In case of Swain's exhibits would not. Others stated that the pages of Shita and register maintained in the office therefore not possible for the defendant. Of the deeds exist. Down to interfere with so what is wrong?
Kindly see
I've read
paragraph 2, 3 and 4 of the plaint, my lord.
huh?
2, 3, 4 of the plaint, my lord. Kindly
So
see
your
how-
case is you see this particular
How-
plot of land which is owned by the plaintiff of 6 katha 4 lechas, ne?
Six kata 4 lesson they are claiming.
You say that you have purchased it from
No,
the
I
mother of the your father has purchased it from the mother of the plaintiff.
3 kata 11 total, both by both the father and mother. Kindly see page, my lord, 28.
Of
Page 28.
yes.
The second RS patta number 165 with only one dark number 276 with area 9 kata 15 chatak of Moja so and so. Under so and so or from RS patta number 160 of said Moja of Pargana. Originally RS patta 160 with only dark number 394 with an area 16 kata 4 chatak. Land was issued and thereafter in acquisition case number so and so and area 6 kata 5 chatak has been made khas. Height order dated so and so and as such there remain area of 9 kata 15 chatak. In the said RS patta number during second resettlement and second RS patta number 165 with tag number 276 with the entire land of RS patta number 9 kata 15 chatak was issued and published. That the mother of the plaintiff, Harabu Bibi, was the owner of the entire 16 kata 4 chatak land of RS patta number 160 along with other land sold to the plaintiff. Height registers the deed of execution and registered on so and so. On receipt of valuable consideration and delivered him first possession of the entire land with specific boundary in the locality who mutated his name by entry dated so and so. Entire concerned Sita. Aforesaid after acquisition of the plaintiff remain in possession of 9 kata 15 chatak. That the plaintiff thereafter sold an area 2 kata subpatta to Harabu Bibi. That is my predecessor. Indirally during RS period. So in the RS patta Jamabandi, Harabu Bibi mutated her name
and the plaintiff along with the Harabu Bibi were the sole pattadar. The plaintiff sold an area of land measuring 1 katha 11 shatak. I registered sale deed number so and so.
No,
Dependent
you
number
say
one.
that the plaintiff sold the land of 6 katha 4 chataks to you.
No, not 6 katha, my lord. This 2 katha and 1 katha 11 shatak.
No, kindly see paragraph 17, page 38 of your written statement. Paragraph 17.
Saying to the effect that 1 katha 11 shatak was sold. It is correct. 1 katha 11 shatak. And thereafter, the sale 6 katha 4 shatak remain. After sale, 6 katha 4 shatak remain.
You read it. I understand. You read it.
But it is not correct that plaintiff has been enjoying the land as much as the plaintiff has sold the land in question to the defendant number 1 with delivery of possession.
So, 6 katha 4 chataks was sold by the plaintiff to the defendant number 1.
It is not correct.
That is your statement.
No. It is said that after selling 1 katha 11 shatak, plaintiff remains 6 katha 4 shatak. And it was in vernacular actually, typed out. 6 katha 4 shatak remain with the plaintiff. Prior to that, 2 katha has been sold to Harabu Bibi. That right also acquired after death of Harabu Bibi. The defendant acquired that 11 shatak. That is 3 katha. And the plaintiff remain 6 katha 4 shataks of land. Now the schedule 2 land mentioned about only 3 katha. And when they have sold out land, we have in possession of this land, the land which they have sold out. Now they are claiming that I have been dispossessed them.
No, you kindly come to page 40.
40. My lord, it is a translated, my lord. Without the vernacular.
Absolutely no. First of all, you don't have a case. We dismiss it right away. Give a proper translated copy anyway.
My lord, may I read the
Supreme Court. Supreme Court. Proper translated copy should be given in the Supreme Court, not here.
I at the time of filing, my lord.
Can't help it.
My lord, may I read out?
No, nothing
That
doing.
part also I have.
Absolutely no. This is not a substantial question of law which has been changed. And there is no other substantial question of law. You said, you see the trial court, the first appellate court decided the issue number 5 actually as issue number 6. Now, while deciding that, it duly had taken note of, your specific contention is Chirag Ali is in possession of Schedule 2, as would appear from the translated copy, which is there. That is your specific statement. Now, why you agree? You are not in possession.
My lord, I am in possession with respect to the land which I have purchased.
We are not concerned. First of all, you have not purchased. You have not proved that document also.
I have proved.
No, you have. Therefore, the first appellate court says.
Both the documents I have proved that
How?
I have.
How did you prove?
I have proved by.
How?
My lord, that is exhibited document.
How? How did you prove?
They have also not denied that they have
Forget
not
about
sold
them.
out land.
I am not on that. It is your burden. You want to bring this thing.
I have brought.
How did you prove?
By way of evidence, my lord. Exhibit.
How? Tell me.
In exhibit, my lord, I.
No. Exhibit won't do. How did you prove that document? Is it 30 years old? When you tendered it?
Yes.
It was 30 years old. Huh?
Yes.
What was the age of that document at Annexure G? Exhibit G and I? Mr. Ghosh, don't make a submission if you don't know.
One is in the year 1962, they have sold out 2 kathas of land. And another 1 katha 11 chata, which has been sold out to the defendant, that is also proved.
How? How did you prove it?
Exhibit G.
Fail to show that the suit land lies in the land for which Exhibit G and I were prepared and executed. Exhibit G and I are what is the age of the documents?
Exhibit G and I in regard to 2 katha and 1 katha 11 chatak. Those already admitted by the plaintiff, lordship. These lordship, we have already admitted that 2 katha we sold to.
Did they show any document to show 6 katha 4
No,
lakh?
lordship. They are paragraph 17 in vernacular also they are saying that plaintiff 6 katha 4 chatak already sold to defendant. There was no deed to prove that same, lordship. G and I in respect to 2 katha and 1 katha 11 chatak. 2 katha.
The case of cost. Nowadays, I've started imposing the cost and giving it not to the other party, to charitable institutions. I don't want to make other people rich. Litigants rich. The rich will be now the charitable institutions. E and H.
Can I? E and H. Huh? It's 1940s.
One was the suit file.
Filed on.
G and I, the first appellate court said that you failed to show that it falls in the suit land.
Can you see the schedule in the G and I?
That is reappreciation.
Can you see that they have misinterpreted?
Enough. Go.
No,
No,
160.
no, enough.
Land is patta number 160.
Sorry.
And it is
Enough.
admitted by the plaintiff that they have sold out the land. It is not the case that they have not sold out the land. They have sold out the land. We have purchased it. Specific case is there.
You failed to show. I'm not going to look into all these things. Chalo.
May I pray that maybe I'll satisfy on.
Oh, no. Second appeal doesn't. This is only for first time one. First timer, when you are there in order 41 rule 11 for the first time, then I do so.
Kindly see the exhibit G and I.
No.
Kindly see the exhibit G and I.
I'm not
and
going to look into
schedule of
it.
the
Sorry.
plane.
I'm
Schedule
not
of the
going to
plane.
look into this.
I don't want to show anything, hello. Exhibit G and I and schedule of the plane.
The first appellate court categorically comes to a finding that you exhibit G and I are not part of the suit land. Matter ends.
That is the wrong finding, my lord.
That is
That
not
the
a
wrong
substantial
finding,
question of law. I'm going to go as per earlier. Because if I have to frame a substantial question of law, then I will have to give them an opportunity of hearing.
My lord, that may, because in the schedule which has been given in the plane and the schedule of this two deed are identically same, my lord. Kindly see.
Done. Now let me dictate.
So far
The
is,
instant appeal is directed again. The judgment and decree dated 7/1/2012, passed in title appeal number 33/2006, whereby the appeal was dismissed and the judgment and decree dated 9/6/2006 entitled suit number 107/2003 was affirmed. This court, by an order dated 5/11/2014, framed a substantial question of law, which reads as under whether in view of the judgment passed by this court by Exhibit N, the learned courts below committed error in declaring title of the plaintiff over the suit land. In view of that specific substantial question of law formulated, this court heard the learned counsels appearing on behalf of both the parties and also have gone through the judgment and order dated 22/8/1989, passed in essay number 10/1980.
89.
89. 89 or 80?
1980, Lordship.
80.
1980.
Full stop. Upon hearing the parties, it appears that the judgment and order so passed in second appeal number 10/1980 was in respect to a different portion of the land which had nothing to do with the suit land. Full stop. Under such circumstances, the said substantial question of law so formulated by this court is not involved in the instant appeal. Be that as it may, the learned counsel appearing on behalf of the appellant submitted that there are substantial questions of law in the instant, which arises in the instant appeal, which requires to be formulated. For the purpose of deciding the proposed questions of law as submitted by Mr. S.K. Ghosh, the learned counsel for the appellant, this court finds it relevant to deal with the facts leading to the filing of the instant appeal. The respondent herein, as plaintiff, filed a suit before the court of the Civil Judge Junior Division number 1, Kachar Silchar, seeking declaration of right, title and interest in respect to the Schedule 1 land. Full stop. The plaintiff's case is that the Schedule 1 land belongs to the plaintiff and the defendants have dispossessed the plaintiff from the Schedule 2 land and as such had sought for recovery of khas possession from the Schedule 2 land. And as the plaintiff was in possession of the Schedule 3 land, have sought for confirmation of possession. In addition to that, the plaintiff have also sought for permanent and temporary injunction and also issuance of a precept to the revenue authorities. The defendant filed a written statement in the written statement. Was admitted that 1 kata of 11 lechas was sold to the defendant by the plaintiff. And after the sale, 6 kata 4 chataks of land remained. It was, however, denied that the plaintiff was enjoying the land in as much as the plaintiff, as per the defendants, had sold the land in question to the defendant number 1 with delivery of possession. It was specifically stated in paragraph number 18 of the written statement that it is the plaintiff's son who had taken over 3 kathas of land in another patta in Jogajugi, which is described in Schedule 2. The defendants further denied the claim of the plaintiff. On the basis of the pleadings, as many as 7 issues were framed, of which issue number 4 was as to whether the plaintiff had any right, title, and interest over the scheduled land. And issue number 5 was as to whether the defendant had dispossessed the plaintiff from the Schedule 1 land. It is, however, for the sake of clarity, this court would further like to observe that Schedule 1 land comprises of Schedule 2 and Schedule 3 land. The Learned Trial Court, by judgment and decree dated 9/6/2006, decreed the suit in favor of the plaintiff, holding that the plaintiff had right, title, and interest over the Schedule 1 land, and the plaintiff be restored possession in respect of the Schedule 2 land by removing the possession and or obstruction or any person claiming through them. The possession of the plaintiff in respect of Schedule 3 was confirmed. In addition to that, the defendants were restrained from dispossessing the plaintiff in respect of the Schedule 1 land and also from interfering with the peaceful possession thereof. The plaintiff's name was also to be restored by the Revenue Authority, and for which a precept was duly issued. Being agreed, an appeal was prepared before the First Appellate Court, which was registered and numbered as Title Appeal number 33/2006. The appeal was, however, dismissed, thereby affirming the judgment and decree passed by the learned trial court. And it is under such circumstances the present appeal. Next. From the above, in the previous segments of the instant judgment, this court have duly taken note of that the substantial question of law which was formulated by this court on 5/11/2014 does not arise, is not involved in the instant appeal in view of the fact nothing could be shown to the effect that the land which was shown that the suit land had any relation with the land which was the subject matter of dispute in essay number 10/1980, for which this court had also held herein above that the said substantial question of law dated framed on 5/11/2014 did not arise is not involved in the instant appeal. In the backdrop of the above, the learned counsel appearing on behalf of the appellant submitted that a substantial question of law arises in the instant appeal in as much as the learned first quotes below. Yes, Mr. Ghosh, what?
Page 13
No. What is your substantial question of law?
regarding dispossession. They have not been able to prove that I have been dispossessed the plaintiff from Schedule 2 land.
Submits that there is a substantial question of law arises in as much as the findings arrived at by by both the courts below that the defendants have dispossessed the plaintiff suffers from perversity. In view of the said submission, this court have also heard Ms. R. Chaudhary, the learned counsel, appearing on behalf of the respondent. Pusto. The issue is to whether the defendant was had dispossessed the plaintiff is actually issue number 5. Pusto. The learned trial court, after taking into account the evidence on record, came to a finding that the plaintiff have duly corroborated the stand taken that the defendant have dispossessed the plaintiff. And this evidence, which was tendered by the plaintiff, will remain consistent and unrebutted. It was also observed by the learned first appellate court that the defendant DW1, the defendant witness number 1 also did not deny that the defendant did not dispossess the plaintiff from the Schedule 2 land. It was also found, it was also observed that the plaintiff had right title and interest over the Schedule 1 land. And his name was deleted, showing that the plaintiff sold the land. However, nothing was shown to prove that the plaintiff in fact sold the entire share of the Sukpatra. Under such circumstances, the learned trial court came to a finding that the defendant have dispossessed the plaintiff from the Schedule 2 land. The issue number 2, say 5, was also decided in the favor of the plaintiff by the first appellate court in a more elaborate manner. Though it was inadvertently mentioned as issue number 6. It is also seen from the judgment of the learned first appellate court that the first appellate court had duly taken note of the evidence which had been placed on record. And came to a finding on the basis of preponderance of probabilities that the plaintiff was dispossessed by the defendants. From the materials on record, as well as the judgment passed by the learned courts below, this court does not find the discussion in respect to the issue number 5 to be a case of perversity for which this court is of the opinion that the question of law so submitted to be formulated by this court at this stage of hearing cannot be formulated. In that view of the matter, this court finds no merit in the instant appeal, for which the appeal stands dismissed with cost quantified at ₹25.
My lord, but my 3 kata 11 land is not with me now. Which is the, I have acquired.
11,000.
Lordship, there is an IA for injunction in that case, status quo till disposal of the IA appeal.
So, matter finish.
2914. Lordship.
The entire case has been decreed.
Return the LCR he can give you, huh? Okay, at least something has been done.
Lordship, in item 27, appellant number 1 died. So if your lordship direct appellant to file amended cost title, lordship, her name can be struck off, other legal heirs are on record, lordship. Vibha Kakoti died.
Who is the appellant? Who is the appellant?
He is the appellant.
So you say the appellant number 1 died.
Vibha Kakoti died, lordship.
Why is the respondent saying that the appellant had died and not the appellant is saying
Yes,
appellant
they are
has
not
died?
saying, lordship, since long it is pending. So memorandum of appeal has to be corrected, lordship.
I have also come to know it recently, lordship. Her legal heirs are on record, lordship.
Item number?
27. 1 and 14 have died.
Is the It has been submitted by Mr. P. Sharma, the learned counsel appearing on behalf of the appellant, that appellant number 1 had expired
And applicant number 14 also.
Huh?
14, 1-4.
as well as appellant number 14. However, their estate is well represented by the other appellants, and as such, there is no requirement for substitution of the appellant number 1 as well as the appellant number 14. Considering the above, this court, CPCD, no? Duly records the said aspect in terms with order 22, rule 2 of the code, and directs the continuance of the instant appeal on the basis of the surviving appellants. The counsel for the appellants is directed to file a fresh memo of parties in view of that.
Deeply obliged.
Not necessary. Fresh memo of parties is not required.
Otherwise,
I'm not
Lord-
striking out. I'm also, you see, order 22 rule 2 only says that you have to put a entry. And this is the entry.
Otherwise, the CI system will record the name of Vibha Kapati, Lordship.
Okay, I'm not striking out. I'm recording it in the order that is dead. That's all.
Amended prospect will not
No,
require. Lordship.
not in this case.
Obliged.
Your Lordship, in
Yes.
regards to item 23, is a old pending matter.
No, old pending. Everything is old pending.
Can I date
Huh?
with it after the vacation?
What?
Item 20,
20?
23.
22 is done.
22 is done.
21, 22, 20, 21 is done. See, when do you want it?
18th of July.
What?
18th of July after the vacation.
Why?
Senior will be available. Sir.
Consult your senior and then come. List the matter after summer vacation.